Right. I think what I was saying, can you devise them? That Whatever.
Correction.
May I have a lordship's kind
Start the
to mention a matter, my lord, for. May I have a lordship's kind leave? Leave, my lord, to mention a matter, my lord, for upgradation, my lord. This is.
Give your slip, sir. Give your slip.
For upgradation, grateful, lord.
Yes. Call the list.
Lordship, may I permit to mentioning?
Give the slip, madam. Yes, call out the list.
But my restoration application, as I indicated, initially there were 8 writ petitioners.
Yes.
Out of the 8 writ petitioners, 4 and 5, writ petition numbers 4 and 5 have taken out this restoration application. Mr. Banerjee appearing on the other side is opposing this application. He has put in an opposition saying that when there were 8 writ petitioners, all of them must join in the prayer for restoration.
Yes.
Otherwise, this cannot be restored. Now, we have used a reply to that opposition also to show that one of them can pray for restoration because everyone has an independent individual right. But now there is a development. The petitioner number 3, writ petitioner number 3, he has given a vokalatnama to my learned advocate on record. He also wants to join me in the prayer for restoration by taking out a separate application. If my lord kindly takes it up in the next week, we'll file a separate application for the petitioner number 3, supply the number and come back.
Not today.
Very well.
Not today.
May we file and mention before your lordship for these 2 restoration applications to be taken up together?
You just mention it, it will be
Great.
there. Once
Great. Another set of
Copy of the application.
Great.
When they'll file it, they'll serve copy. They have not filed it yet. They are in the process of filing. Next week. Not today, next week.
2 and 3 কি করে হলো ওটা বিশ্বজিৎ ঘোষ 2 and 3
Yes.
There is a delay for filing this restoration application,
Yes.
and I have explained the reason of delay in paragraph number 1 of my condonation of delay application.
Yes. Yes.
Not kindly restore the matter.
Yes. All right. J1. J1. This is an application filed for condoning the delay of 62 days. How many? 62 days. 62 days in preferring the restoration application. Full stop. Learned counsel for the petitioner submits that due to medical emergency, he could not attend the hearing on 19/3/2025. Full stop. Thereafter, he filed first restoration application on 13/5/2025, but it was returned by the department due to typographical mistake. Full stop. He could not thereafter file. He could not thereafter file an application due to summer break. Full stop. Now, again, he has filed the restoration application after the reopening. In this process, there is a delay of 62 days. Full stop. The petitioner prays for condoning the said delay as it was not intentional and it was due to unavoidable circumstances as stated in the application herein above. Full stop. Learned counsel for the respondent fairly submits that he has no objection to condoning the delay, full stop. In view thereof, in view of the submissions and for the reasons stated in the application, the delay of 62 days in filing the restoration application is condoned. Application is disposed of.
My lord,
What is
rate,
the-
rate is a very short matter. Itself can be disposed of.
Let's see, GA2. Take down GA2. This is a restoration application filed by the petitioner, full stop. The presented petition was dismissed in default on 19/3/2025 due to non-appearance of the petitioner, full stop. It is learned counsel for the petitioner submits that due to medical emergency, comma, he could not attend the hearing, full stop. He further states that the said non-appearance was unintentional and due to unavoidable medical emergency. Learned counsel for the respondent fairly submits that he has no objection in allowing the restoration application. In view thereof, the present application is allowed for the reasons stated in the said application, full stop. The writ petition is restored to its original position, full stop. Application is disposed of.
My lord, writ petition itself can be disposed if your lordship desire to take up the matter.
What is there? Ashok?
My lord, a very short point is I have applied for certified copy of the order passed by the municipal corporation. 3 sets. They have provided only 1 sets and 2 remaining sets they are not supplying, my lord. This is required for giving exhibited in civil suit 1 and another criminal case matter, my lord. In the prayer, I have mentioned the case number, my lord. Otherwise, original certificate I cannot tender for exhibition.
Yes, Mr.
The only,
Das.
only thing is this, my lord, civil and criminal matter, your lordship knows, as per Evidence Act, he can actually move before the court for the.
No, he is not
got a-
concerned about the civil and
That
criminal.
is, if you lordship kindly see the prayer on page
I
5.
see that, but he only wants the additional set of the
Yes.
certified copy of the
Additional
demolition
2
order.
sets of that will be after following requisites.
I have already paid, my lord.
One he has paid, the second and third, there is a rule. Probably
that-
I have today the building rule. There is one rule that second or third set, my lord, that as per that rule, we will supply him.
Look, kindly
That's
satisfy.
right. My lord, right now, my lord, actually, I was on the impression the matter will be taken up later.
With the consent of the party, present writ petition is taken up for hearing. Full stop. The petitioner has preferred the present writ petition, seeking 2 additional sets of certified copy of the order dated 9/12/2022 and 18/9/2023, passed in demolition case being number 0771-BR-V/2021, Ward 045.
20.
Full stop. It is the case of the petitioner that he had applied for 3 sets of certified copy of the above mentioned order wide application dated 2/6/2023.
24/25 and 24/26.
He states that he has paid the requisite charge
For only 1 copy. He is actually
For-
seeking for another 2 copies.
for 1 set,
1 copy he has received and 2 copies he has not received.
for 1 set. For 1 set of copy. He, learned counsel for the petitioner, states that he is ready and willing to
My lord, 1 point, my lord, 1 point. But
pay.
he has to satisfy the whether I have filed 1 application and I paid for 3 sets. Well, I have to pay 3,000 or that can be satisfied because
Let-
for
let him-
my understanding.
Let him file his report. You want an order? I can pass an order, otherwise let him file his report.
As
He-
per
Yes,
the
yes,
exact rule,
that should be satisfied because I have some misunderstanding. When I have one shot, that has to 1,000. But if I 3
Not
shots
today.
separately,
as per rule 20,
yes,
there
yes,
is 1,000
satisfy
for the year 2024.
Not
all
today.
right, satisfied, then I will pay. No problem, no issue.
Whatever, whenever after 2 weeks, whatever is the date, restored to its original position. Why give a date? Restored to its original position. That's it.
The matter will come as usual, course.
As usual.
Your lordship.
Strike off. He doesn't want.
May it please your lordship. My lord, this is my application for recalling of an order of, my lord, 3rd April 2025. My lord, at the outset, my lord, if I may be candid, my lord, there was some difficulty on our part, my lord, and it was belatedly filed, my lord, with a delay of 26 days. My lord, I apologize, my lord, that the delay has not been explained in my application. But it was dismissed for default, my lord, on the ground that the petitioner was not present when the matter was called, my lord. Lordship, I am humbly praying if the matter may be, my lord, the order may be recalled.
My lord,
Please,
my lord,
my
it
lord,
is
my
not
order.
an application for restoration. My lord, kindly see first page, application for appropriate order. And my lord, after 30 days, application was filed. My lord, it was dismissed on 3rd April. And application was affirmed on, my lord, 12th June, my lord. Section 5
Yes, my lord, I have already indicated,
is
my lord,
required. Section
there
5
is some
is
latches on
required.
the part of the advocate, my lord, but
No, section 5
kindly, my lord,
section
Yes.
5 is required.
What kindly? You have to give some reasons
my
for.
lord, I appreciate your lordship. Kindly, my lord, gives us the liberty to file another separate application for my lord, for
And-
condonation of delay.
And this application is not in formula. It is an application for appropriate order, not application for restoration.
And my lord, my press says so, my lord, for
We are-
calling of the order and restoration of the writ petition, your lordship. At page 8.
Learned counsel for the petitioner seeks to withdraw the present application to file a fresh application with better particulars explaining the reasons for the delay. Full stop. Liberty is granted. The petitioner is at liberty to file another application for condonation of delay.
Well, this is my recalling application, your lordship. I will file, my lord.
Learned counsel for the petition is the liberty is granted. Petitioner is the petitioner is at liberty to file appropriate proceedings in accordance with law.
Get deeply away.
Appropriate proceedings in accordance.
May I please your lordship? Beg to appear on behalf of the petition. Only one kind indulgence, my lord, before my learned senior friend starts off this matter. My lord, I am the owner of the premises and I have not been made a party. So she'll kindly request them to serve a copy of this application on us, my lord, and thereafter whatever happens, my lord.
Up to the Supreme Court adjudication, I don't think they have any right. Supreme Court hasn't held any right in their favor. Can I just open my case for 5 minutes and tell your lordship what the
My lord,
facts?
let him finish. I'll thereafter make my submission on this.
Lord, there is a deed of conveyance in my favor.
Yes.
Now, Lord, based on the deed of conveyance, I applied to the Kolkata Municipal Corporation, and Lord, Kolkata Municipal Corporation mutated my name. If your lordships kindly, Lord, come to page 46.
Yes.
Lord, your lordships will find the name of the petitioners appears at the middle. Page 46, if your lordships kindly look at.
Yes.
At the top, it says mutation certificate. Has your lordship got that?
Yes.
Then, Lord, subject your application for mutation dated such and such. Then, my lord, premises number 195 Picnic Garden Road. Has your lordship found that? Then, my lord, assessee number is given. Then, my lord, the name which are, my lord, being inserted, your lordships will find Money Square Limited, Tripsy Properties, etc. These are the owners of the property. Now, Lord, there was a subsequently amalgamation, and by reason of the order of amalgamation, the petitioner has emerged. Now, Lord, what happened was that there was the property was tenanted. There was a lessee in the property. Now, Lord, the lease expired. On expiry of the lease, around 2010, this mutation, Lord, took place in 2008.
Yes.
Around 2010,
Not annexed.
Lord, they filed a return with the Thika controller.
Yes.
And on such return being filed, they were declared as a Thika tenant permitted to deposit rent. Now, based on that order, they applied to the municipality, and Lord, municipality, Lord, deleted my name and inserted their name. Now, Lord, this proceedings started from the Thika controller to the division bench, ultimately, from Thika controller to the Land Reforms Tenancy Tribunal, then to the division bench, ultimately to the Supreme Court. Division bench, Lord, reversed the order of the Thika controller and the Land Reforms Tenancy Tribunal, saying that the property hasn't vested in the state, because under the Thika Act,
It has to be with the state.
with the declaration, property vests in the state, and Lord, the tenant becomes a Thika tenant under the state. Now, Lord, the point in issue went up to the Supreme Court. Now, Lord, if your lordships kindly, Lord, take the order of the Supreme Court once, which starts at page 114. Lord, please come to 140
Today you have come before this court for what, Mr.
for mutation, Lord, restoring my name.
Restoration.
My restoration of my name on the basis of the judgment of the Supreme Court.
Yes.
Now, Lord, your lordships may kindly come to page 144. The conclusion part, page 120, para 126. Kindly see the conclusion. In summation of what has been discussed herein above, we could broadly say the full bench decision of Calcutta High Court in Lakshmi Moni Das is affirmed. The structure as put up by the appellants and of their predecessors had been Pakka structure on the property. For the structure being Pakka in character and the terms of the lease being 20 years, the appellants and not the predecessors were not Thika tenant within the meaning of section 2(5) of the Act of 1949. The appellants and other predecessors were not Thika tenants within the meaning of Act of 1981 for two major reasons: that the structure in question was a Pakka structure, that the Act of 1981 was not operative in relation to the property in question because the stay order passed by the High Court. Then 5. On the date when the lease expired in the month of November 1993, the appellants and or their predecessors were not Thika tenants, and therefore the Act of 2001 does not inure to their benefit. Then the impugned decision of the High Court therefore calls for no interference. Lord, there were 3 acts: 49 Act, which Lord merged into 1981 Act, and subsequently 2001 Act. Lord, in fact, Lord, my learned junior Lord rightly points out. Please come to page 144, paragraph 124. Para 124. Then the tribunal, in its impugned order, attempted to inject various such philosophies which were simply beside the point. In our view, the High Court has meticulously examined the matter in its right perspective and with apt analysis of all the 3 enactments vis-a-vis the facts of the case, has rightly concluded against the claim of the Thika tenancy of the appellant and or their predecessor. Now, Lord, after yes,
neither the appellants and
paragraph 125, Lord, the impugned orders have been set aside. Now, Lord, the point today is that, Lord, my right, title and interest in the property has been restored after the order of the Supreme Court. So, my Lord, I applied to the municipality. If your lordships, my Lord, kindly take two letters. First, my lord, I applied on 19 June 2023. Kindly see page 112. This was the first letter. P6, yes. Has your lordship got that?
Yes.
Paragraph 3. Paragraph 2, my lord, talks about the order of the High Court. And then, my lord, the protracted long drawn litigation is in paragraph 5. And my lord, ultimately we say, please restore our name in terms of the order passed by the Honorable Supreme Court. That is, my lord, at page 113. So, my lord, when nothing happened in so far as this letter is concerned, then, my lord, we sent another reminder, which is at page 151.
কপি পেয়েছিস? না দেয়নি তো কপি। তুই দেখেছিস পিটিশনের কপি? করে অ্যাপ্লাই করার কিছু নেই, কারণ আমার নাম তো অলরেডি ছিল।
Lord, there was a review application filed which got dismissed. There is a curative petition which also got dismissed. So, my lord, this was brought on record by this letter of 151. Now, my lord,
Orders are annexed 140.
the orders are, my lord, also annexed at starting from page 148. Your lordships will find these orders are there.
Review dismissed, curative dismissed. 147, 148.
148, your lordships will find the review is dismissed. And my lord, 149,
The curative is also
the
dismissed.
curative is
Curative.
dismissed.
Hura and hura.
Hura versus hura. Now, my lord, the issue today is that, my lord, there is a eviction suit filed by me
Yes.
seeking eviction of the tenant, and my lord, the tenant has also filed a suit seeking a declaration that they are in adverse possession.
Yes.
Now, this judgment of the Supreme Court was delivered in 2022. Lord, I want my name to be restored.
Yes.
As of today, the situation is, please come to page 111. As of today, this is the situation. This is obtained on 31st of March to 2025 at page 111. Your lordships will find premises number T, Thika tenant, 195 Picnic Garden Road, ward number so and so. And lord, the occupiers, the Thika tenants are, lord, recorded as owner. Jharna Kumar, Debashish Kumar, etc. So, lord, when the restoration, I asked for restoration because, lord, when the name was removed, I was not given a notice also. Based on this declaration and the deposit of rent, my name was removed, this name was included. Now, lord, 20 years of litigation or 15 years of litigation up to Supreme Court. Now, lord, I can't get my name restored. This is the situation that we are. So, lord, I am kindly look at my prayer. Lord, I am seeking a restoration, and I don't think, lord, a tenant of the property has any right to be heard insofar as my mutation is concerned. Kindly see the prayers at page 17. Roman 2 is what I am asking for.
2 and 3.
And 3.
Prefix T সরাতে।
That prefixation of T has to be removed from the property.
Yes, Mr. Mukherjee.
The object, they were parties. They are bound by Supreme Court.
Huh? What?
Lastly, my learned senior friend has referred to the suits filed by him for khas possession and the suit filed by the
Tenant.
occupiers. Now, my lord, before I go to that part, my lord, he is seeking mutation. and your lordship knows it better than me, that mutation, I do not decide title of the person.
Correct.
What I do
That
is,
will-
the person who would be the best possible person to pay the tax in respect of the property in question. Now, my lord, at this juncture, if your lordship kindly sees the suit, there is no reference in the petition subject to correction. No, this is what the prayer is. This is the suit filed by the, according to my learned senior friend, the unauthorized occupiers. Your lordship has seen the first prayer. And this is their suit of
Money square.
money square. And coupled with that, I have also received a notice of the learned advocate representing those persons named in page 111. Now, this is the situation so far as the property in question.
Mr. Mukherjee, you,
Only thing he can ask for is the consideration of his representation, which he has made. Whether
Mr. Mukherjee,
Yes.
you opened your statement by the word that mutation has nothing to do with the
Of course, my lord, I still stand by my statement
The
that
mutation is only for the purposes that the person
who
who's
is the best
who's
possible
the
person.
owner right now. The dispute, we are not getting into it. There's nothing to do with the dispute. As far as the suits are concerned, they are pending. That will be adjudicated. But today, after the Supreme Court judgment, they are the best possible person to be in occupation. Yes.
Your lordship records that, sends it, because ultimately this court sitting in this jurisdiction has to direct the.
I can
authority
only
concerned.
see today, I can only give a direction to the extent that the representation will be decided by you.
Taking into consideration the judgment of the Honorable Supreme Court, no issues so far as that portion is
Yes.
concerned.
But if you
By
want
doing
further
that-
finding by this court, then you file your report, then I'll pass it on.
Correct. I think
Lord,
calls for a
My
report.
lord, may I
Please
just
call for a
indicate
report.
Mr.
There
Court's client today do not have any title. I'll
Sir,
just,
title
may I just make-
dispute, you decide
yes, my
in
lord,
your
only
civil.
one thing, the Supreme Court judgment does not give him title either. My lord, he
You
has.
Contest your title suit in
Yes,
the
my lord.
civil court.
That is of course, my lord. The Supreme Court judgment did not proceed on a title dispute. It was only to the extent apropos my status as a tenant under the state. So, my lord, the adjudication that I am not a tenant under the state does not vest Mr. Kaur's client with any right whatsoever, excepting to the extent, my lord, that I will not be paying rent to the state. Now, with regards to this application, my lord, what has not been indicated to your lordships is this, that they had attempted to have me evicted from the Supreme Court itself. Kindly seize this application. And kindly seize the Supreme Court order.
The Supreme Court will not get into
Of
your
course.
eviction.
Supreme Court has not given him any right to him.
Supreme Court is not going to decide the title dispute between the
Absolutely.
parties.
And no, and further to the extent, the rights which Mr. Kaur claims as an alleged owner, my lord, that does not exist. I can today, my lord, have Mr. Kaur's property registered in my name by some fictitious deed. That does not give me title.
We are not on the title.
Yes, my lord. So if, my lord, lordship will kindly remand it back, let the municipal consideration.
Lord,
And
even
I
in
will
his suit,
position, and I,
Enjoy your possession. We are
Yes.
not getting into your possession.
yes, first possession can only be filed.
and
Today, my lord, lordship is fully aware, my lord, the Supreme Court has clearly laid down that the issue of adverse possession is no longer an issue of shield.
Sir, you argue all that in your civil suit. Why are you arguing all this over here? Am I deciding your title dispute?
Lordship just records what I have
So,
just.
Mr. Kaur, there are two things which you can get. One, they'll consider your representation in terms of the order passed by the Supreme Court. Second, they'll file their report, then we'll decide.
Lord, let them file a report and then Lord pass the order. Yes, because Lord, once for all, Lord, this situation, Lord, otherwise we will not get justice there. Let the report come.
Lord, is that even, I'm making only one humble prayer. Lordship can direct them to serve a copy of the writ petition because I'm a necessary.
No, absolutely not.
So I'm a necessary and a proper party. I have a
Move,
right which might be affected by this.
sorry, sir, I don't see that. All right. Take down. The
So that
petitioner,
did not be heard in this writ petition.
move an application, we'll see that. We'll see whether you need to be heard, not heard. Application allowed, not allowed.
Of course, it's up to your Lordship's discretion.
The petitioner has filed the present writ petition, comma, being aggrieved by the inaction of the respondent in failing to reinstate the petitioner's name as the sole owner of premises T. Premises number, now T goes, right? Premises number 190.
199.
195, comma, Picnic Garden Road, Calcutta, comma, and also to rectify the description of the said property in the municipal records, full stop. The case of the petition is that they are the absolute owner of the premises in question. The premise in question, full stop. The erstwhile owner had granted a 20-year lease of the said premises to Kumar Industries.
Yes, I'm
To MS Kumar Industries by way of a registered lease deed dated 15/12/1973. Subsequently, comma, MS Kumar Industries, comma, by order dated 27/1/2010 of the Thika controller, comma, Kolkata, was declared Thika tenants under the West Bengal Thika Tenancy Acquisition and Regulation Act 2001, comma, and were permitted to deposit rent with the Thika controller, full stop. Based on this order, MS Kumar Industries had the property recorded in their name as Thika tenant, full stop. As Thika tenant, and the description of property was altered to T-195 Picnic Garden Road, Calcutta, indicating its status as Thika tenancy land, full stop. The petitioner challenged the said order dated 27/1/2010 before this court, and this court wide order dated. What is the order date of the order?
I'll give your Lordship the order. The division bench's order is dated 10th March 2014.
The Honorable Division Bench of this court, by an order dated 10th March
2014.
2014, had held that the said land is not a Thika tenancy, full stop. The said order was appealed before the Honorable Supreme Court, and ultimately by the judgment dated 27/7/2022, the Honorable Supreme Court held that MS Kumar Industries were not Thika tenants in respect of the said premises, and thereby dismissed their claim, full stop. The review petition and curative petitions were filed against the said judgment, met with the same fate of dismissal, full stop. Thereafter, the petitioner, comma, by representation dated 19/6 and
2020 and Lord 30th December 2024.
19/6 and 30th December 19/6/24 and 23, sorry, and
30th December
30th December 24, comma, requested the municipal corporation to amend the municipal records by recording the petitioner as the absolute owner and to rectify the description of the property, comma, which no longer qualifies as Thika tenancy land, full stop. However, till date, the respondent has not acted upon the said representations, full stop. Learned counsel for the respondent corporation seeks and is granted how much time?
3 weeks to file the report.
3.
Kindly shorten
You
the
want to
time.
file affidavit in opposition, you want to file report, what do you want to file?
Call for a report, Lord, instead of affidavit. Huh?
Call for an opposition would be better idea. You finish off. Report will have more issues.
My junior insists that there should be an affidavit. Let there be an affidavit.
Affidavit is a better,
3 weeks.
so that
No,
Either way, 3 weeks. Otherwise, Mr. Mukherjee will make 2 prayers. Then again, he'll say, I'll file a full opposition.
Lord, kindly,
Make it audible.
kindly,
learned counsel
kindly
for the respondent, Mr.
abridge the time.
Mukherjee
Kindly give
seeks
2
and
weeks.
is granted 3 weeks time to file his affidavit in opposition. Reply to the same, if any, within 1 week. List after 4 weeks. After 4 weeks?
Great.
File your application, we'll see.
Very lucky litigation. We have been making, as lawyers, we have had a lot of benefit out of it.
I can see that.
Let that
12 years we have been enjoying. That benefit is feeling
let that
going on and on.
let that benefit continue.
Benefit, the size will speak of the benefit.
This litigation has really helped people.
I can only say that it is balanced. Looking at both sides.
Sir, it is not helping you.
My junior says in between, corporation is sandwich.
But what a tasty patty for a sandwich.
I have filed an application. Your lordship has been earlier occasion has been pleased to direct the corporation to submit evidence. In the form of evidence. Kindly see the order, 24th April. 24th April. 24th April, kindly see the order.
24th of April.
Report in the form of evidence, your lordship is clearly directed. On 24th April, kindly see second page. Second paragraph. হয়নি কেন এখন তো ঠিক আছে কতদিন লাগবে সেটা তো হয়েছে report in the form of evidence. Kindly see second paragraph. Yes to second paragraph.
Where's the affidavit filed? Yes.
Report has come, my lord.
Yes,
The
that's the
affidavit has not been made ready, but it will be a part of the affidavit, of course, my lord. If you lost my lord, because I have got it only yesterday.
Last occasion your lordship has been take time on that ground.
It will be annexed to the affidavit. Of course, my lord should directed my to in the form of affidavit.
No, you have to file it by in the
File.
form of affidavit. Learned counsel for the respondent seeks and is granted further time of 1 week. 1 week to comply with the order dated 24th of April 2025. List after 2 weeks. Do you want to file your objection to the exception to the report?
Yes, my lord. I will file my lord. My lord, one more thing, my lord.
Reply, objection if any within 1 week thereafter, list after 3 weeks.
Yeah, one copy be served.
Within a week, your lordship directed us, I will give it within a week.
All right,
And they will file an objection to the report, if any, and
1 week, 3 weeks, after 3 weeks.
My lord, one
Yes,
more
sir.
thing. One more thing, my lord. There is an order of this court by an order dated 19th April 2024. There is a direction upon the CSC to disconnect the electricity connection
in respect of the unauthorized construction. My lord.
Let them
My lord.
file their report, then we'll see.
My lord. My lord, the thing is that the CSC has approached them. They are not cooperating with the
We will
CSC.
see, sir. Let them file their report. Let us see whether the
My lord.
nature of the construction.
This one. Three. This
Number 7, I am for the petition. May it please you.
I am for the respondent number 3, man.
What happened in this matter? There was a direction by a coordinate bench of this court to hold a hearing regarding the new mutation. Accordingly, that hearing was held, and our mutation has been cancelled, and the names of the earlier mutation who are all dead, their names have been restored. Now let me place the specific, the relevant portion of the order on the basis of which this hearing took place. That order is annexed as annexure
P7, page 66.
Page
66. 66.
See your lordship's order.
Not your lordship's order.
Sorry.
This order is passed by
Coordinate.
her lordship, the ombudsman. The most important part of the relevant portion of this order is this. Information mentions that no hearing was conducted prior to the mutation being effected. According to the previous provisions of that is in a running page 67, the second page of the order. I am
Second last paragraph.
Paragraphs. Lordship. Page number 67, running page, I am taking the last 4 paragraphs. The information mentions that no hearing was conducted prior to the mutation being effected. According to the provisions of law, if the corporation intends to delete the name of the recorded owner and mutate the property in respect of the applicant, then an opportunity of hearing is to be provided to the person whose name is sought to be deleted from the municipal records. In the present case, admittedly, mutation was made without affording any opportunity of hearing to erstwhile recorded owners of the property. Now, in this context, please to come to the letter of intimation dated 29/12/2020. It is in annexure P2, page 51. Page 51. Now the thing is this, all getting the erstwhile. The thing is this, all the erstwhile recorded owners are dead. So formally, a letter of intimation was served upon the address of all the erstwhile recorded owners, as well as the present applicant. But since all are dead, how the hearing would take place? So naturally, what happened? Subsequently, on the basis of the application of the present applicant, the mutation was ultimately granted in favor of them. That is in annexure P4, page 55. But letter of intimation was very much served upon all the erstwhile recorded owners. But since all of them are dead, nobody could turn up. So accordingly, on the basis of the application made by us, mutation has been granted. It is in page 55, annexure P4. Prior to that, no due certificate. So I have annexed some of the death certificate which are available to me. That is in annexure P5. Death certificates of the erstwhile recorded owners. That is in page 5. That is Amitabh Yogi, Shailendranath Sen, Prafullo Kumar Sen, Renuka Roy, Ranjan Yogi, etc., etc. Some more recorded owners are there. This are available to us. We have annexed. Now, the thing is this, prior to that, we have cleared all the dues of the corporation, and we have obtained a no due certificate. That is also annexed. Mm-hmm. 152. Yes, we have the total due was 18,52,509. It is in the letter of intimation. We have cleared the entire dues. And page 54 is the NOC, no due certificate. Page 54. Since we have cleared the entire dues, as of till date, no due certificate was issued to us, and accordingly, mutation certificate was granted to us. Now the private respondent number 3 and 4 have challenged this mutation certificate. In fact, they have no locus standi at all. In earlier petition, the private respondent number 3, Sri Tapabrata Brahmachari, claimed himself as a member of this trust. I do hereby submit your lordships in no material points of time, either respondent number 4 or respondent number 3 or 4. In no material points of time, they were related to this trust at any point of time. They belong to some other, maybe some other trust, some other Tapabrata Brahmachari. He was a pujari of some nearby temple, nearby mandir. Actually, their main motto is to grab the property, grab the trust for nothing else. What is their locus standi? How they are so much interested? So there is no illegality at all. Here, notice of intimation was duly served upon all the erstwhile recorded owners, but since all of them are dead, no hearing could take place. The amount which is due to this trust, we have cleared the entire dues, and no due certificate was issued. That is in page 54. No outstanding certificate, NOC. And subsequently, mutation was granted in our favor, rightly. Now the thing is this: be that as it may, since the coordinate bench has directed the KMC authority to hold the hearing, KMC authority prior to that, come to annexure P6, page 61. A criminal procedure was initiated in the court of the learned 3rd Executive Magistrate, Kolkata, in Metropolitan Magistrates Court. That is the annexure P4 against the respondent number 4 and his associates. An appropriate order was passed. In connivance with the respondent number 3 and 4, they have done all the mischiefs. Only their intention to grab the trust forward, nothing else. The petition under section 144(2) is annexed. That is in annexure page 61, annexure page 61, annexure P6, and an order is also there. Annexure P6. The OC Amar State Police Station was appropriately directed to maintain peace and harmony in the application. On presentation of the state documents, I find it expedient to call for a report from the OC Amar State PS regarding the allegations made in the application. Anyway, thereafter, the writ petition was filed, and coordinated bench directed the KMC authority to hold the hearing after issuing notice to all the parties. Accordingly, hearing was held on 22nd July. 22nd July, intimation was served. Hearing was held on 21st July 2023. 21st July 2023. And we have challenged the outcome of this hearing. Now I am placing the relevant portion of this relevant portion of this orders.
যেটা বলো তোমরা skip করো। কিন্তু সেটা হলো।
Yes,
I am placing the relevant portion of the order which is the subject matter of challenge in this writ petition. That is in page 72. I am placing the I am reading out from paragraph number 2, page 70, paragraph number 2. On the other hand, as per verbal and written representation submitted during the time of hearing, Pratap Chandra Mujumdar Memorial Charitable Trust, present recorded owner, the Pratap Chandra Mujumdar Memorial Trust, and Sri Tapabrata Brahmachari, the petitioners herein have no locus standi to file the instant application, and the unfounded allegation made by them are speculative, fictitious, harassing, not based on material fact, and liable to be dismissed, and also bad for misgender and non-gender parties. They additionally contended that the instant trust was brought into exercise by deed of trust dated 8th March 1928, wherein the instant premises was made a part of the trust by the then trustees, namely Prafulla Chandra Sen, Sri Anil Kumar Moitro, Sri Sharajendranath Sen, Renuka Roy, and Udayan Chatterjee. From 1960 onwards, the then trustees, Amitav Nyogi and others, inducted one tenant in respect of this property, namely Choturmukh. And as per verbal agreement made between the parties, it was agreed that the said tenant would release this property in or before 1970. But the said tenant had not vacated the premises, and to that effect, the trustees filed one title suit before the learned City Civil Court at Calcutta, being titles number 1395 of 1974, and that suit was decreed in favor of the trustees. Thereafter, the said trustees mutated their names in the record of the Kolkata Municipal Corporation in respect of the said premises. Then one resolution was passed on 5th February 2013 by the trustees of Pratap Chandra Mujumdar Memorial Trust, and it was declared that the name of the said trust had been changed to Pratap Chandra Mujumdar Memorial Charitable Trust. Sri Ranjan Nyogi was selected as the chairman, Mrs. Tulsi Kormukar and as the vice chairman, and Sri Priyaranjan Mukherjee as the secretary of Pratap Chandra Mujumdar Memorial Charitable Trust. Another resolution was passed on 6 May 2013 by the trustees of Pratap Chandra Mujumdar Memorial Charitable Trust, and it was decided that two outsiders, namely Tapabrata Brahmachari and Arun Kumar Roy, in connivance with one of the staff of the trust, namely Majid Akhtar, had been devising plan to grab this trust property by illegal means. Another resolution was passed on 10th January 2014 by the trustees of Pratap Chandra Mujumdar Memorial Charitable Trust, and it was decided that two outsiders, namely Tapabrata Brahmachari and Arun Kumar Roy, who are the private respondents in this petition, in connivance with one of the staff of the trust, namely Majid Akhtar, had been causing annoyance and disturbances in the peaceful day-to-day activities and restoring to illegal activities to grab the trust property. Now, some more resolution was passed. Now, come to the last paragraph of page 72. They also added that the secretary of Pratap Chandra Mujumdar Memorial Charitable Trust, due to high-handed activities of Arun Roy, Samina Akhtar, and Majid Akhtar, filed two separate cases under section 144(2) of the Code of Criminal Procedure and under section 200 CRPC. And after hearing, the learned court was pleased to direct the officer in charge of Amar State Police Station to see that no breach of peace should take place at the disputed locality. In 2021, the present trustees of Pratap Chandra Mujumdar Memorial Charitable Trust applied for mutation before the Kolkata Municipal Corporation, and the same was granted. by the Mutation Authority. At that time, they paid municipal property tax amounting to rupees 18,52,609. On 13th May 2021, said Mujid Akhtar applied for mutation before Kolkata Municipal Corporation, which was rejected by the municipal authority. In the meantime, said Mujid Akhtar filed one title suit, being number 1332 of 2021, pending before the learned 10th City Civil Court at Calcutta in connivance with Tapabodha Brahmachari and Arun Roy against Priyaranjan Mukherjee and others. In that petition, said Mujid Akhtar, claiming himself as the owner of this property, filed 2 deeds and obtained injunction from the learned court. After receiving the said plaint, the present owner of this property filed 2 deeds. The present trustees, Priyaranjan Mukherjee and Muhammad Shahnawaz, appeared before the court and filed objections. Subsequently, it was found that the 2 deeds filed by Mujid Akhtar were false and fabricated. In this respect, Priyaranjan Mukherjee, the secretary of Pratap Chandra Majumdar Memorial Charitable Trust, lodged a written complaint with the Amar State Police Station, being the FIR number 21 of 2023 under section 406, 420, 467, 468, 469, 471 and 120B of the Indian Penal Code, and subsequently said Mujid Akhtar and his brother were arrested. Lastly, upon consideration of all their submissions, they prayed for rejection of the objection submitted by Pratap Chandra Memorial Trust and Tapabodha Brahmachari, the petitioner's hearing.
Sir, why have you not made Pratap Chandra Memorial a party here?
Pratap Chandra, it is our trust. Pratap Chandra.
There are 2 trusts, sir. Pratap Chandra Memorial Trust and Pratap Chandra Charitable Trust. You are charitable.
Memorial Trust, it has been converted to Pratap Chandra Majumdar Memorial Charitable Trust, since some charitable activities were inducted.
So no trust can get converted like this.
Only name has been changed. Name
Can't be changed like this, sir. Where are the members? There is some
same members.
No, sir. There is something fishy here. This is
one.
The first petition was filed by Pratap Chandra Memorial Trust. If you are the reading, the order which you are reading,
from the Majumdar Memorial Charitable Trust,
not charitable. It is first one is Pratap Chandra Memorial Trust.
That matter has not been filed by us.
I know that is not filed.
Previous petition.
Where are the previous members of that trust? Make the trust a party. How have you changed this name? Name doesn't change.
Should be a resolution.
Resolution.
Should be a resolution.
Memorial Trust.
One minute.
Sir, he is here.
Lordship.
Have you made him a party? He is saying he is member of the Pratap Chandra Memorial Trust.
Who? He is the private respondent actually.
Sir,
he is the private respondent.
He is claiming to be a member of the trust. You don't change trust like this. You don't change trust like this.
Lordship.
This is all fishy and nothing else.
Pratap Chandra Majumdar Memorial Trust.
Pratap Chandra Memorial Trust is a different entity, and Pratap Chandra Memorial Charitable Trust is a different entity.
What is the
There are 2 different entities. You don't change name of the trust like this by a resolution.
Both of the trusts are
registration is done with the sir.
Both of the trusts registered trust. Registered trust.
Registered maybe. You don't change. They can't interchange like this.
Lordship, I understand.
Trust don't interchange like this, sir.
I understand.
It is a registered entity.
Registered entity.
And both are different entity. Have you merged?
Registered by us only.
I don't know whether it is registered by you or not. I don't trust you.
Registered documents are there.
Sir,
Lordship.
None of the registered documents are here. What registered document have you put in here?
Yes. The registered deed of trust.
Registered deed of trust only creates a trust.
Yes.
It doesn't mean that you have both merged. What documents you have to support that?
Lordship. Then in that event, I will also
make them a party.
Let me check. Lordship. Let me check. Certificate copy of registered deed of trust. I have annexed only one certificate copy.
Sir,
I am also having
better make Pratap Chandra Memorial Trust a party to the present proceeding.
Leave may be granted to that effect.
Just now you said both are same.
Leave may be granted to that effect.
Now you want a leave to All hanky.
They are they are claiming as the member of the Pratap Chandra Majumdar Memorial Trust. Nothing
You are
else.
claiming to be a usurper who's taking the property.
Anyway, leave me grant. I'll make Pratap Chandra Memorial Trust a part.
Learned counsel the petitioner seeks leave to make Pratap Chandra Mazumdar Memorial Trust a party to the present writ petition. Full stop.
আপনি হচ্ছেন
Liberty is granted
charitable.
to add Pratap
Not do
Chandra
any charity.
Memorial Trust a party to the present writ proceedings. Necessary steps shall be taken in this regard.
Cheating words. Grateful to your lordship.
All, Mr.
My lord,
Banerjee.
your lordship has seen my order.
No. That
My lord,
I could understand that there is
there is a lot of hodgepodge in the whole. My lord would kindly see he initially he did not annex the entire order in the writ petition. Subsequently, it was done.
That was
The supplementary affidavit is with your lordship.
there's no supplementary.
I haven't filed any supplementary affidavit, but the order has copy. My lord, for your
Order
lordship
is order is there.
consideration, I'm giving.
Yes.
My lord, would pardon me because part of it is been marked.
No, not a
My
problem.
lord, 5-page order has been passed dealing in its entirety. My lord, would kindly come to the penultimate page, page 74. Page 74, that is the last running page.
Yes.
My lord, would take from the deed of trust. So and so registered at the office. Original trust is of 1928.
yes.
One Priyaranjan Mukherjee executed this deed of trust, settler founder. Name of this trust was defined as Pratap Chandra Majumdar Memorial Charitable Trust with its office at 84 Acharya Prafulla Chandra Road. Total 22 numbers of objects were declared. Priyaranjan Mukherjee, the settler herein, was creating an endowment by settling apart and for establishing a fund for public charitable object and purpose in India expressed in this deed of trust, and hence he had contributed, my lord would kindly note how much, 10,000 for this purpose. From the detailed recitation of both the above stated deeds of trust, it has been found no movable property was granted or transferred or conveyed unto the trustees of Pratap Chandra Majumdar Memorial Charitable Trust, though through execution of either of deeds. Only a fund of 10,000 was created and granted upon the trustees of Pratap Chandra Majumdar Memorial Charitable Trust. Hence, conveyance of ownership of premises 84. This is the premises which they want to grab. Acharya Prafulla Chandra Road, Kolkata, from Pratap Chandra Majumdar Memorial Trust to Pratap Chandra Majumdar Memorial Charitable Trust by way of execution of these two deeds of trust was not happened. Moreover, in respect of appointment of the trustees, it was very specifically mentioned in the original deed of trust, trust deed, executed by Saudamini Majumdar on 4th of March 1928, bearing number so and so, that no person shall be appointed a trustee under these presents who is or may be antagonistic to the ideal and principle of new dispensation. This obligatory condition of the original trust deed doesn't fulfill in case, well, thereafter, Muhammad Shahnawaz or his religion is described as Muslim in the trust deed, number so and so, 9 September 14, and also in case of Priyaranjan Mukherjee, since his religion is described as Hindu
in the trust deed bearing number so and so, my lord.
So in the
Malad,
trust
there-
deed, Hindu Muslim will come. In the deed of
My lord,
trust.
I
Please
did
trust.
not utter a single word till you are making a submission. Please keep quiet. Now, my lord, this trust is originally of Brahmos.
Yes.
Brahmos, started by Raja Ram Mohan Raj.
1920.
Yes, they control and possess this property. Now this is trying to be siphoned away by making these fishy and fictitious deeds. Now, my lord, I'll just read it. In the resolution meeting of the trustees of the Pratap Chandra Majumdar Memorial Trust, so and so, it was recorded that the name of the trust was needed to be amended from so and so to so and so. Also in resolution of the meeting of the trustees of Pratap Chandra Majumdar Memorial Charitable Trust, dated so and so, it was recorded that it was necessary to mutate the name of the new trustees. In the records of the Kolkata Municipal Corporation, in respect of the premises number so and so, in pursuance of, in pursuance of the trust deed dated 3rd May 1970. But it has already been noticed that the conveyance of the ownership of the premises number 84 Prafulla Chandra Road from Pratap Chandra Majumdar Memorial Trust to Pratap Chandra Majumdar Memorial Charitable Trust. This is the jugglery going on. By way of execution of any of the two submitted deeds of trust was not made. Moreover, Pratap Chandra Majumdar Memorial Trust, being the petitioner of the instant writ petition before the Honorable Court itself, is still in existence. Probably my learned friend is representing them,
I shall come up with the original trust.
which indicates the amendment of the name of trust as recorded in the resolution dated February 13 is not beyond the question of law, which requires adjudication and appropriate order from the competent court of law or any other appropriate authority. Hence, my lord, we restored the name of the person who are originally from 1928, that is the Memorial Trust.
And who are all dead.
That is not your concern at all. If they are dead, they have gone in the grave. It is not your concern. Who are you? You are just a cipher. You are just a cipher.
Take down, madam. Take down. The petitioner has preferred the present writ petition being aggrieved by the order dated 21/7/23 passed by the assessor collector, assessor and collector north, KMC, whereby the mutation granted qua premises number 84 Acharya Prafulla Chandra Road in favor of the petitioner was cancelled and restored it to the name of the earlier recorded owners.
That is who were petitioners before my Lord Justice Amrita Sinha.
This is the
They are not the petitioner.
this is the second round of this is the second round of litigation. Full stop. Earlier WPO WPA 27999 of 2022, titled as Pratap Chandra Majumdar Memorial Trust versus the state of West Bengal, was filed before this court, alleging that the respondent corporation, carried out mutation dated 13/5/2021, qua the property in question, in favor of the petitioner herein, i.e. Pratap Chandra Majumdar Memorial Charitable Trust. Word charitable is added here. comma, without giving an opportunity of hearing to the earlier recorded owners, comma, a full stop. In view thereof, this court, wide order dated 31/1/2023, 31/1/2023, comma, remanded the matter back to the respondent corporation with a direction to pass a speaking order after hearing all the concerned parties, full stop. Hence, comma, the assessor and collector, comma, after hearing the petitioners, comma, pass the impugned order dated 21/7/2023, comma, whereby cancelled the mutation of the property in question in favor of the petitioner. Being agreed by the same, the petitioner has preferred the presented petition. Prima facie, this court is of the view that the petitioner intentionally has not made Pratap Chandra Mazumdar Memorial Trust a party in the present writ petition. Also, from the order passed by the assessor and collector, it is evident that the Pratap Chandra Memorial Trust was established in the year 1928 and the present trust, which is Pratap Chand Memorial Charitable Trust, has been established in the year 2017. Full stop. The
Trustee board members are the inheritor of the
It-
relatives of the earlier trustee board
it prima facie looks that the present trust, Pratap Chandra Mazumdar Memorial Charitable Trust, is set up for taking over the immovable property of the earlier Pratap Chandra Memorial Trust and full stop. There is no document on record to put forth the contention that the Pratap Chandra Memorial Charitable Trust has in any way merged or has inherited the property 84 Acharya Prafulla Chandra Road, for which it is seeking mutation in its name. Full stop. At this stage, learned counsel for the respondent, I can dismiss it, but I want your reply.
Very good. You're also liberal to file a supplementary affidavit
For what?
stating that the chain of inheritance, how the present member related to the erstwhile members of the trust.
Related will not put them, sir. You have formed a separate charitable trust only to grab this property and nothing.
Certainly not. No question of grabbing the property.
Nothing else.
We are maintaining the property. from
Learned
the very
counsel
beginning.
for the respondent corporation seeks and is granted 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. List after 6 weeks. Full stop. At this stage, learned counsel for the petitioner seeks to add Pratap Chandra Memorial Trust, a party respondent to the presented petition. Liberty is granted to the petitioner to add Pratap Chand Memorial Trust, a party to the present writ petition. necessary steps shall be taken. Full stop.
Leave may also be granted to file a supplementary affidavit stating some.
That we will see, sir. No leave.
Leave to file an affidavit of opposition by the private respondent.
You have not even made a party. First become a party, then we will see that.
Application korun একটা for addition of party.
In the department, shall I amend the cost title? Or should I amend the cost title here and now? Or in the department?
Department.
Proxy.
Eight pilot, this is my application. My lord, I have sought for separate water connections and for permission for construction of new water reservoir, my lord. Last question. Lord, I purchased the property, my lord. My property deed is annexed, my lord, which is at page, my lord, 19 it starts. My lord, relevant at
Yes,
page
yes.
27.
Just a minute. Hey. Tagging तो ठीक क्या करो यार क्या है? How will a person read this? यहाँ टैग करो. टैग करके दो मुझे. Wait a minute. Let. Yes.
My lord, I sought for.
Yes.
My lord, petitioner has sought for, my lord, separate water connection and construction of water reservoir, my lord. I purchased the portion of a property, my lord. My deed is annexed at page 19, my lord, relevant at page 27, my lord. Where, my lord, there was specific terms,
Page.
27, my lord. The vendor undergo to share the water supply to the purchaser and his tenant so long the purchaser get his separate water connection from the corporation. But thereafter, my lord, my name has been mutated, my lord, in the KMC record, having a separate assessee number, my lord, which is at page, my lord, 38 onwards, my lord. Separate assessee number is also there, my lord, 38.
If the vendor is not complying by the terms and condition, you know
Now,
what
my
to
lord,
do.
vendor has sold his portion also, my lord.
Very good.
Now, my lord, the portion which was purchased by the intending purchaser, my lord, there was a dispute, private dispute, my lord. For that, my lord, the suit is going on, my lord, in the trial court, my lord,
Very good.
admittedly. Now, my lord, last occasion, my lord, the corporation has filed. In the meantime, my lord, we have
Corporation
we have
has
made
filed,
two representation, my lord. Corporation has
corporation has filed a report.
report, my lord.
Have you filed an exception to
Exception,
that?
my lord. I have filed an exceptions, my
Right.
lord. My lord, in the report, my lord, I find, my lord, the provision which the corporation is relying on, my lord, there is no direct embargo, my lord, for giving connections, my lord. Rather, my lord, 267 of the KMC Act, it provides, my lord, additional supply, my lord.
First you argue your case, sir, then we'll go on to 66.
My lord,
First argue your facts.
my lord, I shall. Now, my lord, the suit, my lord, which was filed by the private respondent, my lord, I have annexed the plaint, my lord, which start at page 76, my lord, which is a mandatory and permanent injunction, my lord. The relevant
Page?
portion, page 76 of my writ petition.
Yes. We'll come back and hear this matter. We'll come back in 5 minutes. Give a copy of the exception.
Exception copy. My lord, I'm supplying.
You are there, Mr. Ghosh, in this matter.
No, exception copy though.
And
The affidavit of My lord, this is my application, my lord. Lord, I have sought for separate water connection, my lord, and water reservoir, my lord. Permission for water reservoir, my lord. Now, my lord, I have already placed before your lordship the relevant portion of the deed from which I have purchased. There is a clause, my lord, for water connection, my lord. Now my vendor has sold out his property, his portion, to some third party, my lord. Now they are in possession of that property, my lord. Now, my lord, the dispute thereafter, my lord, I muted my name in the Kolkata Municipal Corporation, my lord. The next page, page 37, annexure P2, my lord, where from it transpired, my lord, my SSC number, my tax bill, all are there, my lord.
Yes.
Lord, thereafter, my lord, there was a dispute, my lord, with that, my lord, the private parties, my lord, the private respondent herein, my lord. So, my lord, the water has been stopped, my lord. So, my lord, I made a representation before the KMC, my lord, which is annexed at page 42, my lord. This is the representation made by the client himself, my lord. 42 and 43, my lord. My lord, when it was not done, my lord, there was a lawyer representation, my lord, subsequently, which is annexed at page 40. Page 45, my lord, there was another representation, my lord, annexure P5, my lord. It was also done by the petitioner himself, my lord, and thereafter the lawyer representation, my lord, which start at page 62, annexure P6, my lord. The corporation did not supply the, my lord, water, my lord. Therefore, this red petition, my lord. My lord, admittedly, there was a dispute with the private respondent, my lord. In the trial court, the suit is pending, my lord. In the trial court, my lord, the private respondent has filed a suit for mandatory and permanent injunction. I have annexed the plaint, which is start at page 76. My lord, kindly comes to page 81, paragraph 15, my lord. The plaintiff further filed this suit for mandatory injunction for a direction upon the defendant to arrange a separate water system inside the portion of the defendant premises, which is more fully described in the B schedule herein. Lord, page 82, my lord, thereafter, my lord, prayer B, my lord, mandatory injunction directing the defendant to arrange a separate water system reservoir inside the premises of defendant, which is more fully described in the schedule B herein below, my lord. So, my lord, the private respondent, my lord, have no problem. My lord, we have a separate water connection, my lord. But they have a problem if that water connections, if you use the earlier water connection, my lord. So there was a dispute, my lord. Now, my lord, last occasion, my lord, the corporation, my learned senior respected friend, has submitted a report before this court.
Yes.
Stating certain provision of the law of the Kolkata Municipal Corporation Act, saying that no such connection can be granted, my lord.
Yes.
But as I find, my lord, there is no direct embargo, which I have taken, my lord, in my exceptions, my lord. There is no direct embargo in the act itself. On the contrary, my lord, from their report, section 267, my lord, I am relying on their report 267. Where, my lord, there is a provision of additional water. My lord, may I hand up?
I have power to require water supply to be taken.
Yes, my lord. 267. Subclause A, my lord, to take connection from the supply main of the corporation adequate for the requirement of the person occupying or employed in the premises, or to take such additional or enlarged connection or connection from the supply mains. So, my lord, there is a provision of additional supply, my lord. My lord, my first respect to submission, my lord. My lord, I should have get a separate connections, my lord. If it is not, my lord, your lordship knows, my lord, water is a life, my lord. Without water, my lord, a person cannot. My client is aged about 80, my lord, is an octogenarian, my lord. It's very difficult for the water, my lord. At least, my lord, maybe, my lord, tax may be enhanced, my lord. Here is a provisions from where I find the tax may be enhanced, my lord. That, my lord, I will pay, my lord.
Show me from the act.
My lord, 267, my lord, it, my lord, may I read inter provision, my lord? If it appears to the municipal commissioner that any premises in Kolkata are without supply of wholesome water for domestic purpose, or that existing supply of water or domestic purpose available for the purpose usually occupying or employed in such premises is inadequate or on any sanitary ground objectionable, the municipal commissioner may by notice in writing require the owner of the premises of or the person primarily liable for payment of the property tax in respect of the same, my lord. And thereafter comes, my lord, provision A, my lord, to take a connection from the supply main of the corporation adequate for the requirement of the person occupying or employed in the premises, or to take such additional or enlarged connection or connection from the supply main. Next, my lord, comes to provide supply pipes, the water fitting and install and work a pump and do all such work and take all such measure as may in the option of the Kolkata municipal
Please read
commissioner.
266, sir.
My lord, 266. New premises not to be occupied without arrangement for water supply. No person shall occupy or cause or permit to be occupied any premises or part thereof constructed or reconstructed after the commencement of this act until he has obtained a certificate from the municipal commissioner that there is provided with or with a reasonable distance of the premises such supply of wholesome water as appear to the municipal commissioner to be adequate for the person who may occupy to be employed in such premises for this domestic purpose.
See, this is a civil dispute between both of you. Both are the owners of that 25A. That issue has to be resolved. The corporation is very clear to the extent that they provide water connection, one building, one connection. One property, one connection. Two connections cannot be given to one property.
Difficulty
And you
is
both
this,
are owners of this property, 25A.
the separate
Separate
assessing number.
connection
Having a separate assessing number.
number is fine.
And the most ambiguity, my lord, there is no definition clause. The premises is not defined, my lord, in the KMC Act itself.
That's, sir, as far as the corporation is concerned, their stand is very clear that you already have a reservoir, you already have a water connection, you have to sort it out, which you are doing with your neighbor or your whatever relative of whatever he is.
My lord, my lord, Article 21 is violated, my lord. I'm before a read court, my lord. Court of
That's
equity.
all
my
right,
lord.
sir, but then I can't direct something which can't be done.
My lord, the constitution overrides every provisions, my lord. My respectful submission, my lord. And there is no direct embargo, my lord. There is no direct embargo, my lord. That there is a direct embargo, my lord. Let the corporation show a provision, my lord. That there is a direct embargo.
The direct embargo is 266. You should not shift in a property till the time you don't have a certificate of water connection. Where's your certificate of water connection before you shifted in the property? Where's your certificate before you occupy the property?
My lord,
You need a certificate of water connection in your property. That is a requirement under the law. Where is the certificate?
Lord, certificate, so far this certificate is concerned, my lord.
Now, when you are talking about constitution and the law, let us follow the law. To the best of the letter and spirit of law. Where is the certificate?
My lord, at least I am entitled for additional connection, my lord. What I submit, my lord, my second field of submission, my lord, at least I am
Additional
entitled from the
connection, sir.
mains.
One property, one connection. Is
Right.
their stand? You show me from the act or the rule.
But it is nowhere has been written, my lord, one property, one connection in the act itself, my lord. Let them show, my lord, I am out of court, my lord.
It's not about the act. This is the policy. Corporation runs by a policy. If they start
Lord,
giving,
if it is not there, my lord, policy, my lord, is a different thing, my lord. They can make their policy, they can change their policy, my lord. It is not written, my lord.
all right. Anything else?
No, my lord.
Yes. Mr. Ghosh.
Submitting your lordship, precisely when he is asking for that there should be more than one connection in one premises.
Yes.
Admittedly, this is one premises.
Yes.
There is co-owners are there. Petitioner number, petitioner, and there is one number 10. What I find, my lord, there is a dispute regarding the enjoyment of the supply, which according to us in adequate supply is in the premises. There is a dispute, my lord, regarding the enjoyment of supply of water.
Yes.
Normally, he has saying repeatedly that is a separate SSC number.
Yes.
Because he is occupying is not a vertically divisible premises.
Yes.
So one premises in a way that it cannot be, my lord, divide in a vertically divided.
Yes.
Had it been vertically divided, then there could be a separate premises number. He cannot, my lord, get a separate premises number since it is not a totally vertically divisible. Section is very clear that when a premises number is allotted,
Yes.
when it is a separate premises, it's not a completely separate premises. Therefore, it is, my lord, two
So
premises.
how have you given him separate SSC numbers?
But separate because he, my lord, acquires a particular portion depending on the area is assessed as a single unit.
For
Entire
the,
premises is assessed as a single unit.
for the purposes of property tax.
Property tax according to the depending on the area in his occupation.
So then you have demarcated a property.
No, area. But I ascertain the area which is in occupation.
So if you have ascertained the area, then that means there's a division of the property.
The division of the property, so far the property tax is concerned. Assessment, apportionment is concerned. He is, my lord, admitted the apportionment is there. The law provides, my lord, for apportionment 178 is clear. 178 clears, my lord, they pay.
Let us see 170.
My lord. Logically come to, my lord, the section 178.
Yes.
second, the subsection 2, under the rules as opposed to every building together with the site and the land appertaining thereto shall be as a single unit,
Yes.
provided that where the portion of any building together with the site and the land appertaining thereto are vertically divisible and are separately owned so as to be entirely independent and capable of separate enjoyment, notwithstanding the fact that the access to such separate portion is made through a common passage or a common staircase, such separately owned portion may be accessed separately.
Yes.
And then if you look, come to my lord, the section.
So that is what I'm saying.
My lord?
If you read that, provided that where portions of any building together with the site and the land appurtenant, they too are vertically divisible. You are saying nothing is divisible, vertically divisible and are separately owned so as to entirely independent and capable of separate enjoyment, notwithstanding the fact that the access to such
Yes.
separate portion is made through a common passage or common staircase,
Yes,
such
sir.
separately owned portion may be assessed separately.
Right.
So under 177, 178, you have already declared them to be a separate assessee.
No, I have
So
my lord,
that
first of all,
means-
it has been assessed as a single unit. It can be separately assessed provided it is a vertically divisible. But here it is not a vertically divisible. Therefore, when the section subsection 6 comes in, if it is vertically divisible, it can be separately assessed.
So if it is
If it is
vertically
separately
divisible,
assessed,
you can
separate-
give him separate connection also.
Separately assessed means, my lord, separate number will be given separately assessed. But where a joint is there, is a single unit, then my lord, section 6, my lord, realistically come to subsection 6.
Yes.
The municipal commissioner shall, upon an application made in this behalf by an owner, lessee or sublessee or occupier, if any land or building, or upon payment of such fees as may be determined by the corporation, by regulation, furnish information to such persons regarding the apportionment of the property tax of such land or building among the several occupiers. And if you last about his representation, that is the apportion share. And his representation is at page. Just I'm giving. Basically, come to page 143. That I am the owner of the southern portion of the above premises, apportioned share, and the northern portion is owned by an occupied Mr. Muhammad Ahmed. Both of us, the same ferule from which the filtered water is stored to the underground reservoir situated at the portion of the Mehbudal. Since the last few years dispute cropped up between us, at present some title suit is pending before the Alipur Judges Court. The above-mentioned persons, Mr. Mehmood Ahmed, intentionally creating trouble in supply of filtered water to me, as the water reservoir and the water pump situated at his portion, and at present I am suffering tremendous shortage of filtered water. Now, logically come to section, my lord, 254. Power of the commissioner to allow connection of premises to service mains. The municipal commissioner may permit the owner, lessee or occupier of any premises to connect the premises by means of supply of pipes for occupying to the premises a supply of wholesome water. Therefore, a supply of wholesome in a particular premises is a one premises 25 years Samsuluda Road. They are the co-owners. But I cannot give to premises unless it is a separate premises. And my ecologically kindly come to next one, 265B.
260?
265B, size of the ferule. Adequacy depending on the size of the ferule, and that size of the ferule is allotted on the basis of the amount of annual valuation.
No, but what about power to require separate supply pipes?
My lord?
255.
255, my lord. It's a different, my lord. Geological, can you see 255? To request
Two.
separate supply of pipes, the municipal commissioner may require the provisions of a separate supply of pipe for each of the premises. Therefore, each of the premises, these are one premises. Therefore, it does not say about anywhere.
Read number 2.
Hello?
Number 2.
Number 2, if in the case of any premises already supplied with the water but not having a separate supply pipe, the municipal commissioner gives notice to the owner of the premises requiring the provisions of such pipe. The owner shall, within 3 months, lay so much of the required pipes as is not required to be laid in a street, and the municipal commissioner shall lay so much of the required pipe as to be laid in a street and make all necessary commission. All, my lord, relating to the premises in question. The pipes were required for the supply of pipes. That pipes were not sufficient. Then the supplies, my lord, the pipe to be the authority, my lord, required that the size of the pipe to be, my lord, to be made there. Now, my lord, the supply of water comes by basically 265B now. 265B.
65B. May where the supply is made.
265B, my lord, got it?
May where the supply of water is made by any other purpose be levied on the basis of the size
No,
of the ferule.
265B, determination of size of the ferule.
Determination of the size of
265B.
the size of the ferule attached to the supply pipe.
Size of the ferule attached to the supply pipe in any premises or building shall be determined on the basis of the annual valuation of the premises as may be fixed by the regulation. Therefore, whatever the annual valuation, taking together of both the portions, on the basis of that, my lord, ferule has been, my lord, installed. And through that, my lord, water goes in. But my problem, as I understand, that the gentleman with the other portion is not supplying. What he could do, as I feel, my lord, that when the pipe, my lord, through the ferule, my lord, the water goes in the premises, they can take a Y-shape connection. But he cannot insist on a separate supply connection. প্রশ্ন দাঁড়াও না, প্রশ্ন না।
Yes. Anything else? This you are enjoying the property since?
My lord, I have purchased the property. From 1988, my lord.
1988. Suit filed?
Suit filed in 2015.
Suit is pending?
Yes, yes.
Even in the suit you are asking for? What are you asking for in the suit?
Suit, my lord, this is their
Suit is
suit.
filed by them.
Yes, my lord.
And you also.
Yes,
yes.
both happen.
What are you asking for in the suit?
Suit for, my lord, just a minute. Suit er ekhane কাগজটা বার করুন। Petition. 10টা।
He is asking that you should avail your water connection from some other source. That is what he is asking for. right? To remove the water pump from the portion of the
Yes,
plaintiff's
yes,
premise.
yes.
And what are you asking for?
My lord, এটা আমার তো, ওটাই নাও।
See, sir, you are getting water
Okay.
connection today. It is not that you don't have a water connection. You have water connection.
The plaint, my lord, look for declaration and permanent injunction, my lord.
You already have a water connection. You
Well,
are enjoying the water connection,
And separate system is asking for in the petition.
and you are asking for a separate system. Permanent injunction against what?
Lord, here, my lord, I have prayed for declaration that I am the absolute owner of 16 ana, owner of the A schedule property. Declaration of the B schedule property is the common passage, my lord. Decree for permanent injunction restraining the defendant from obstructing. My lord, internal page 6, my lord.
Underground reservoir to the petition in the suit property. Also, defendant to remove overhead water tank which is situated at the common attic. The issue is already seized off in the before the civil court. Why should this court interfere today?
Lord,
You already have a water connection. Why a
But,
separate water connection
in
should be given?
267, my lord, I have a provision for additional, my lord. That is what I am praying, my lord. And my lord, 234B, my lord has asked for, my lord, the provision of tax, my lord. My lord, kindly, my lord, once, my lord, 234B, my lord.
234B.
B, my lord. There is a provision, my lord, of the KMC Act
Yes.
for residential building or premises owned by the state government or any statutory body which are occupied in flat and where no annual valuation may be apportioned separately for each such flat, the fee for supply of water may be levied on each occupier on the basis of the area in occupation in such manner as may be determined by the regulation.
How does this help you? How does this help you, sir?
Well, it's a residential building, my lord.
Who's denying you don't have a residential building?
Yes, my lord.
The problem is it's a one residential unit.
Yes, way supply is mentioned.
My lord, my learned friend has replied, my lord, it was apportionment. Like here, my lord, has been stated, my lord, specifically the annual valuation may be appointed separately, apportioned separately for each such flat. The fee for supply of water may be levied on each occupier on the basis of the area in occupation in such manner as may be determined by the regulation.
Take down. Petitioner. The petitioner has filed the present writ petition seeking a direction upon the respondent municipality to permit the construction of a separate underground water reservoir, and to grant a separate water supply connection through an independent parole, subject to compliance with all necessary formalities. Learned counsel for the petitioner submits that he is the absolute owner of the southern portion of the premises located at 25A, Samshul Khuda Road, Post Office, Circus Avenue, Police Station, Karaya, Calcutta, while respondent number 10 is the absolute owner of the northern portion of the said four-storied building. It's a four-storied building. Yes, full stop. Both derive their title by virtue of a registered sale conveyance deed dated 14/3/1988 and 17/1/2007, respectively. Full stop. It is further asserted that the petitioner and respondent number 10 jointly holds all easementary and user right over the eastern common passage, the staircase, the common passage, the staircase and the staircase is from the ground to the fourth.
Yes, ma'am.
Staircase extended from the ground floor to the rooftop, and the the septic tank and the underground reservoir. Full stop. The respective portions of the property have been, you have got a mutation,
My lord.
duly mutated in the names of the petitioner and respondent number 10 with separate assessee numbers assigned to both of them. Full stop. Dispute arose between the petitioner and respondent number 10 regarding the use of common areas and civil suit number 93 and civil suits in this regard are presently pending before the competent civil court. Full stop. It is alleged that the respondent number 10 is obstructing the petitioner, petitioner's access to and use of water from the existing underground reservoir. Full stop. Consequently, the petitioner approached the respondent municipality seeking separate connection, seeking permission to construct a separate underground reservoir and to obtain a separate water connection. Full stop. However, the municipality had failed to respond to the petitioner's request, prompting the petitioner to file the present writ petition. Respondent municipality, Mr. Alok Ghosh, counsel for the respondent municipality, has filed a report stating that the entire premises bearing number 25A, Shamshul Hoda Road, is treated as a single unit. Full stop. According to the municipality, both the petitioner and the respondent number 10 are co-owners of the building. Full stop. The petitioner is occupying the southern portion of the building and the respondent number 10 is occupying the northern portion of the building, inclusive of shared common facilities. Full stop. It is further stated by Mr. Ghosh that the property is not vertically divisible. Full stop. It is further submitted that the premises already enjoys a water supply connection through a ferrule of maximum permissible size, comma, determined on the annual valuation of the land and building in terms of the Calcutta Municipal Corporation Act, full stop. He further contends that under the provisions of the Calcutta Municipal Corporation Act and in accordance with the prevailing official instructions, comma, only one domestic water connection is permissible per premises, irrespective of ownership. Hence, there is no provision for a separate water connection to the same premises. Learned counsel for the petitioner has learned counsel of the petitioner controverts the said stand of the respondent corporation and states that the property has two assessee numbers and thus is entitled to a separate water connection. Full stop. He further relies on section, which section you rely on?
267.
267 to buttress his argument that since the corporation buttress his argument relies on section 267 to buttress his argument and states that under the said provision, the corporation is at liberty to grant a separate water connection to the premises of the petitioner. Full stop. What else? This is it.
Upon levying tax, my lord.
In terms of the annual valuation of the property tax paid by him. Full stop. Learned counsel for the counsel for the respondent corporation states that section 266 records that no person should occupy or permit to be occupied in any premise unless until there is a certificate obtained from the municipality that the said premise has a water connection. He further relies on section, which is the other one, Mr.
Getting size of the ferrule.
Size of the ferrule.
265B, madam.
250.
265B. 265.
He further relies on section 265B, where he says that the property has been adequately assessed for supply of the water connection and the ferrule of maximum capacity has already been placed on the said premises.
Then 254 says that one connection to be supplied in a premises. A supply of both of one.
He further relies on section 254, which records that one supply should be provided to the premises.
Particular premises.
Full stop. This court has heard the arguments advanced by the counsel for the parties and has perused the materials on record. full stop. The respondent, it is well settled. It is well settled proposition. As a karta. It is has produced the materials on record. The petitioner had purchased the said property in the year, it is 2088. The petitioner had purchased the said property in the year 1988 and has been enjoying the water connection to the said premises since then. Later in the year 2007, the property was further divided and another occupant, i.e. respondent number 10, became the owner of the property in 2007, right? In the year 2007. Both the petitioner as well as the respondent number 7 have been respondent number 10 has been enjoying the water connection on the said premises for more than decades. Full stop. Only when dispute arose between the petitioner and the respondent number 10 that they resorted to filing of civil suits. Full stop. Petitioner has filed a civil suit wherein civil suit number 1448 of 2010, wherein the petitioner had asked for a permanent injunction against respondent number 10 for not disturbing his underground reservoir as well as the pump room and the pump installed on the site. The petitioner also has filed a suit title number 93 of 2015, wherein the petitioner had sought for removal of the water pump of the petitioner. Full stop. The issue of water connection is sub judice before the civil court. Full stop. The petitioner has filed the present writ petition as an alternate to the grant of water connection which is already existing on the premises of the petitioner. Full stop. In view of the submissions made by the in view of the submissions made by the learned counsel for the respondent, it is well settled that the determination to the feasibility and grant of water supply connection falls within the exclusive domain of the respondent municipality, comma, which is the expert authority in such matters. Full stop. Such decisions necessarily involve consideration of factors such as water availability, comma, infrastructure feasibility, comma, and broader municipal policy and existing laws and regulations. Full stop. The respondent has, comma, in exercise of its discretion and in adherence to its stated policy, comma, has taken a considered decision not to grant more than one water connection for a single premise. Full stop. The petitioner has not been able to demonstrate any malified or arbitrariness in the stand taken by the respondent municipality. Full stop. It is not the case of the petitioner that any similarly situated persons have been treated differently or more favorably. Rather, the petitioner has been enjoying the water connection to the said property since the year 1988, and only after a dispute arose with respondent number 10 that the petitioner thought of seeking an alternate water connection. To say that the petitioner has been denied his fundamental right to enjoyment of water connection will be unfair, since the petitioner has been adequately enjoying the water connection, and only due to the civil dispute between petitioner and the respondent number 10 that the petitioner has filed the present writ petition. Full stop. In the light of the clear and reasoned stand taken by the respondent municipality, and in the absence of any illegality or arbitrariness in its action, this court finds no ground to interfere. Full stop. Accordingly, the present writ petition is dismissed.
But this second suit has been filed by the private respondent number 10, my lord.
Suit
93 of
number
2015.
93 is filed by respondent number 10.
No.
93 one.
93
You
of
filed
20
1448, he filed 93, right?
Yes, yes.
You should directly, officer, your lordship, you should mention the municipality to mention the corporation. And another Calcutta Municipal Corporation and possibly gone down, Kolkata Municipal Corporation.
Calcutta.
Number 9.
Yes.
I appear for the petitioner in this matter. This is an issue that we have filed a writ petition. And we have subsequently found out that the private respondent had passed away in 2005. We have taken out an application for substitution. Service has been effected. Affidavit of service is on record. We have served it on the office.
May I submit on the last occasion, in view that the respondent who sought to be substituted died before filing of the writ petition, your lordship submitted to file an alternative application for addition of parties, not substitution. That corrected might not be had filed, because we'll find from the lordship from the substitution application, he died before filing of the writ petition. So appropriate application would be an addition of parties.
There are some judgments, I can demonstrate before your lordship.
But how can a dead person institute a petition?
No, I am the petitioner, I am alive. The private respondent has passed.
That's what I'm saying. How can you ask for any relief against a dead person, sir?
I have taken out an application for substitution.
Substitution would be, sir, the application should be for impediment of the legal heirs. You can't ask for a relief against a dead person, can you?
Yes, yes.
Substitution will be a wrong word
Yes.
to be used here.
Well, I'll file a fresh application.
Can't seek relief against a dead person.
Yes.
Learned counsel for the petitioner states that he will be filing appropriate. He seeks and is granted an adjournment till when do you want this matter to be adjourned till?
Fortnight's time, I'll file it.
Seeks and is granted. At the request of the learned counsel petition, let this matter be adjourned for 4 weeks.
Grateful.
In this matter, I am for the
Yes.
petition. My lord, what happened, my lord? Premises number 15A, Acharya Jagdish Chandra Bose Road, owned by the petitioner, my lord. Petitioner is the absolute owner. My lord.
What are you seeking?
My lord, I am seeking, my lord, straight away I am telling you, lordship, my lord, kindly come to my lord, page, a photograph I have, my lord, annexed of my building, page 35. It is a single-storied building, old building. There, one tenant was there.
we petitioner rehabilitated them in separate place. But so the parts, various parts of the building, including roof. This is a photograph. Before your lord's roof chunk has been, my lord, collapsed, my lord.
Not
My lord,
collapsed.
yes, yes, entirely. My lord, kindly see a great chunk of the roof. A single story building and different parts, wall, staircase. I have only relied on two photographs. So, my lord, this single story building, it can't be, my lord, repaired, my lord, at any stage, because single story building. My lord, so the petitioner, my lord, sent representation to the Kolkata Municipal Corporation. My lord, kindly come to last page, my lord, page 36, annexure P3. To the Commissioner, Kolkata Municipal Corporation, subject request for demolition of dilapidated building at premises number 15A, Acharya Jagadish Chandra Bose Road, Kolkata 7,17,000. I, the undersigned, lordship got it.
I'm reading it.
Yes, I, the undersigned, being owner, bring to your urgent attention the dire condition of the building situated at premises of 15A, Acharya Jagadish Chandra Bose Road, Kolkata 7,17,000. The structure has become severely dilapidated and poses a serious threat to human life. The building exhibits extensive cracks in the walls, sagging, ceiling, partial collapse, and unsuitable foundation, making it highly unsafe for occupancy or even proximity. The situation worsened during inclement weather, increasing the risk of collapse and potential harm to nearby residents and passerby. The premises is vacant, and locked since years ago, as it endangers human life in any point of time, at any point of time. Given to the hazardous condition of the premises, I earnestly request the Kolkata Municipal Corporation to take immediate steps to demolish the building to prevent any untoward incident. I believe this action is necessary to ensure safety and structural integrity. I trust that you will treat this matter with urgency and it deserves the initiate demolition process at early. A similar representation to the officer in charge of Park Street Police Station. But my lord, since then, my lord, since receipt of this, I have served this through registered post. Since receipt of this, no, my lord, response, no action has been taken, my lord. My lord, so, my lord, I filed this receipt application. My lord, I am also, my lord, annexed, my lord, the rent receipt, my lord. The one tenant was there, but we, my lord, reallocated him. And original tenant died to his widow. So, my lord, building is vacant. Building is inhabitable condition. No way to demolish and new construction to be carried out. For that reason, my lord, just to invoke, my lord, 411 or 412A, my lord, of the Kolkata Municipal Corporation Act, my lord, kindly see, I am reading 411, my lord. Kindly have a look. Power to order removal of dangerous buildings. If any wall of the or building or any affixed thereto, anything affixed thereto be deemed by the municipal commissioner to be in a ruinous state, the building is a ruinous state, or likely to fall, or to be in any way dangerous, he shall forthwith cause a written notice to be served on the owner and to be put on some conspicuous part of the wall or building, or served on the occupier. If any of the building requiring such owner or occupier forthwith to demolish, repair or secure such wall, building or things as the case may require, provided that in the case of a heritage, it is not a heritage building. Number 2, municipal commissioner may, if it appears to him necessary, so do so, cause proper hoarding, fence or other means of protection to be put up at the expense of owner of such wall or building for the safety of the public or the inmates thereof. So, for the safety of the public and for better user of the premises, because it becomes, my lord, useless, my lord. And for that reason, my lord, I pray before your lordships, either under section 411 or 412A, declare the building unsafe and dilapidated. Kindly necessary process be, my lord.
Whose building is it anyway? Your lordships.
My building.
Petitioner's building, he is not taking care of. There is tenant as per the petition.
Yes,
He has not party. If your lordships kindly.
Yes, I
come
made
to-
party. I
Abhi-
made
abhi
party.
boli nahi humne.
I made party.
My lord,
Sir, now you have spoken. We
my
heard
lord,
you.
my lord, kindly.
What
say-
is this habit of interfering in between? When you were speaking, did he interfere?
Yes, yes.
What yes?
What?
When you were speaking, did he interfere?
Oh, sorry, sir.
Then why are you
So
speaking?
I made party to the sole tenant.
Let him speak.
Absolutely.
My lord, as per paragraph 4, first question, my lord, that is the today's, that is the owner straightway come to the read code and giving a praying for a direction upon the corporation. Corporation is direct, no straightway direct duty for demolish each and every building if they are actually, they can consider. The second part is, my lord, my argument, my lord, that is page 3. If you lords kindly see paragraph 4,
Yes.
that is single storied, and the that is if you lords got it. Have you lords got it? While paragraph 4, building is single storied. The first line, my lord, that the building though in a single storied one.
Yes.
And then, my lord, if your lords kindly come to page 23, the building is 2-storied and partly 3-storied. So it's a absolutely an untrue statement. And now, my lord, if your lords kindly come to the prayer B, that is the prayer, and order be passed to vacate the building under question if any inhabitant occupied the same illegally beyond the petitioner's knowledge. It is his building. There are, my lord, that is the, as per his, my lord, that is schedule, there are wholly tenanted building. And, my lord, that is the prayer. If there is anybody who will actually disposes him. The only thing is this, my lord, regarding this case, I beseech to your lordship to direct. Honestly, there are how many tenants are there? They should be made party, because previously there is one order from a learned single judge to added them party, because his right, who is there, his right will be affected. Today I have no
My lord,
report.
there is one tenant, and as per provision of 412A, my lord, kindly see, my lord, and I also read one 411, corporation issued notice, my lord, no problem, notwithstanding anything contrary contained in in this act or in any other law for the time being in force, or in any agreement, custom or usage, or in any decree, judgment, decision or award of any court, tribunal or authority, where it appears to the municipal commissioner that demolition of a dangerous building under section 411 will cause hardship to the person in occupation. There is no occupation of such building, and may not be conducive to public interest in an urban area suffering from acute shortage. So, my lord, here, my lord, if there is any person is in occupation, my lord, the photograph, it can't be disputed. Photograph shows the chunk of the roof has fallen down and several other parts fallen down, damaged. So there is no inhabitant. I submitted before your lordships that one tenant was there. I made him party and I shifted him in elsewhere, my lord. For abundant precaution, just to meet my learned friend, I made him party. I made her party. I said, so no one is occupying there. If the corporation is disputing the same, corporation send notice. Corporation send under as stipulated in section 411, 412A. And second thing is, nowhere I mention the status of the building 2-storied or partly 3-storied. Building is single-storied building, my lord. And my lord, I never stated anywhere they are fully tenanted or there are several tenants. Only one tenant. Wherefore my learned friend submitted all these things, I don't know. So it is not that
Mr. Das, what you are reading on page 23, that is a will of a person who has had several properties, and the one you read out is a different property.
There is 123 Balaram Dey Street.
Yes, quite.
That's a different property.
You come page 16, my lord.
Just a minute, sir.
No.
Not today.
Page 16.
Learn how to address the court.
My lord.
This is no way to address the court. We are not sitting here to, it's not a fish market. Give the file.
Yeah. My lord, similar.
We'll have this after lunch.
After lunch.
After lunch. One more word and I'll dismiss this petition.
I'm just pointing out
the old man, you're getting super excited. Did you pass out yesterday? Is this your first matter?
prayer, my lord, from
Joint prayer, my lord, in assigned matter, a demolition proceeding
is
is
going
going
on.
on, and action is going on.
My lord, may it be listed, my lord, tomorrow, anytime, anytime. My lord, in the appellate side, my lord, there is
Honorable regular bench is in
Not-
circuit, therefore not we have to disturb it.
no regular bench has passed an order. My lord.
Yes, yes.
Regular bench has passed an order.
Yes, my lord, asking us to approach the honorable division bench.
Oh, that matter where you have the protection. It will be listed tomorrow.
Yes, let it be listed tomorrow,
Tomorrow.
appellate side. Well, no problem. Well, we'll take our chance. Well, I know your lordships. Let the matter appear.
Tomorrow.
Let it, my lord. Then, my lord, we can do something about it. Kindly, my lord, with folded hands.
Appellate side.
It's an appellate side.
Hmm.
Well,
Tomorrow. Keep it for tomorrow.
very good. With the appellate side. Calcutta the
Tomorrow first matter.
It-
This happiness won't last. Are you protected?
Well, I am before my lord. Well, I am before my
I've seen the file. Tomorrow.
Your lordship with your.
No mentioning right now, sir. No mentioning. This is not the time to mention. Mentioning is in the morning.
My lord, I may be excused, your lordships. I am grateful to your lordships.
Yes.
Just previous page, the previous number is there. I missed it, your lordship. The previous page, my lord, 23 instead of 22. I missed it.
Page 22.
22, lordship. That is there. Yes. My lord, regarding this, my lord, the executive engineer, I talked with him. May I place one report regarding the condition of the building? His prayer is also that. Or, my lord, I may consider the representation, whichever you
Consider the representation.
consider the representation, my lord. There is a provision 411. Owner is himself demolished the building by my order.
Consider his representation.
Lordship.
Take down.
Our
Petitioner. The petitioner
what time?
has preferred the present petition seeking a direction against the respondent municipality for declaring the building being number, 15A, ACJ Bose Road, Calcutta as dangerous building and further seeking a direction to the respondent municipality to demolish the said dangerous and unsafe building. It is the case of the petitioner that he is the owner of the above mentioned property, full stop. The said structure is an old and is a very old dilapidated single storied building, full stop. He states that many parts of the said building are in a vulnerable state and can collapse at any time. He has placed a photograph along with the writ petition wherein he supports his contention that the said roof has collapsed. Full stop. He states that the present structure of the building has become completely uninhabitable and dangerous. Full stop. Learned counsel for the petitioner further states that there was one tenant in the property who he has made a party before this court, but he contends that the tenant has left the property. Full stop. he counsel further states that he had approached the respondent authorities via representation dated 26/12/2024 for the demolition of the said building. Full stop. However, till date, no steps have been taken by the respondent to declare the said building as dangerous. Full stop. Being agreed by the same, the petitioner has approached this court. Full stop. Learned counsel for the respondent corporation refutes the stand of the petitioner and states that some other tenants might be staying in the property. He further contends that the pictures annexed with the present writ petition cannot only ascertain the nature of the building being dangerous. Be that it may, he, learned counsel for the respondent, states that he is ready and willing to consider and decide petitioner's representation dated 26/12/2024. Full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is decided within a time-bound manner. In view of the statement made by the counsel for the parties, this court directs the respondent. Which one?
That is 4, my lord. Executive engineer.
Respond number 4 to decide petitioner's representation dated 26/12/2024 strictly in accordance with law within a period of Mr. Das 8 weeks.
2 days, my lord.
Within a period of 8 weeks. Within a period of 8 weeks from the date of communication of this order, after affording an opportunity of personal hearing to the petitioner, as well as
Interested
other stakeholders who might be staying in the said property by way of a speaking order. With the above direction, the present writ petition is disposed.
I am getting.
Item number 11, my lord, I am for the petition and late by Arindam Banerjee, senior counsel. He was there, my lord.
Yes, he was here.
He has a fixed matter before courtroom number 28. He is on his legs before courtroom number 28, my lord. Now, on his ground, I am praying for an accommodation, my lord.
Proxy counsel so and so appears and states that the main arguing counsel, Mr. Arindam Mukherjee, is busy in another court. She requests for a short adjournment. When do you want?
Next week.
Next week.
Let this matter be listed next week. Who's next Thursday? Who's for the corporation here?
Mr. Ghosh is appearing in this matter, but he is arguing in another matter.
All right, we'll have it next Thursday.
Lordship.
Next. Mr. Ghosh.
Item number 12, Lord, I appear for the petitioner in this matter.
Yes.
But in this matter, Lord, in the last occasion, Lord, pursuant to an earlier order passed by this honorable court dated January 15, 2025, Lordship had directed the corporation to file a report as to the status of the action taken by the corporation.
Lordship. Lordship.
Lord, by
Shall we be entitled to get a copy?
I will, after judgment report. तो देखो ना,
What kind of a report is this?
my lord, if your lordships kindly take the page 20, the previous order passed by this honorable.
What kind of a report, Mr. Das?
My lord, this report, my lord,
What does this officer think?
my lord, this officer, my lord, if your lordships kindly, your lordships, I understand what is fallen from.
What does he think? He's
Well-
filing a report before the High Court.
My lord, this report, if your lordships kindly, if your lordships right, my lord, only page 20.
Mr. Das, you tell this officer.
My-
I'll initiate inquiry against him.
Only give him another chance. I am beseech your lordships, only the
Don't even show this report to me.
lordship, I should not. My lord, only thing, my lord, if your lordship,
Tell this officer, Mr. Das.
my lord, give me some more time, my
Does
lord.
he want to serve or he wants to retire?
My lord, absolutely, my lord.
What?
Sorry, my lord, I should not place it before your lordships at last, on the last moment, the report.
Take
has
down.
been- Give me some more time, your lordship, kindly not take the report. I am extremely sorry, if your lordships, I should not place it. I am sorry.
How can you file a report like this before this court? Has he made so much money that he wants to retire? Don't take this court for a ride. Learned counsel for the respondent corporation seeks and is granted further time of 2 weeks.
My lord.
2 weeks to
But
comply.
instead of 3 weeks, because my lord, one order was passed by
3
the
weeks.
honorable court, which is actually converted 408 to 401. That's why my lord 401 before the special officer. He has not actually writing the report correctly. The thing remains, your lordships may be permitted. I understand your lordships agony. I am also very ashamed. But the thing remains, the honorable court on the previous round of litigation, both the party constructed the illegal construction. Now both the parties approached before this honorable court. The order was passed at that point of time, 408. I have no information. I appeared. And then, my lord, that 408, right now it is 408, but due to the order passed by the honorable court, if your lordships, Justice Honorable Justice Kaushik Chandra, that is converted into 401. 401, due to that, my lord, that record is actually sent to the special officer building, my lord. That is the thing. But my lord, give me time, my lord. I actually convey your lordship.
Takes further time of
Kindly, lord.
3 weeks. 3 weeks, 4 weeks.
It is some more time, my lord, because two
4
buildings
weeks.
are illegal.
4 weeks. Pass an order, demolition order, take
Lordship.
action, file a report.
Lordship.
Within a period of 4 weeks. Seeks and is granted further time of 4 weeks to
report.
file his report as directed by this court by order dated 22nd of May 2025. Reply to the same, if any, within 1 week thereafter, list after 6 weeks.
May I take back the report? I am
Yes, please. Give back the report.
I am sorry, my lord.
Great.
My lord, I am for the petition in this.
For the TMC. Lordship, I am praying for short passover, Lordship. Actually, this is a
But on
very
the other day,
critical
Mr. Ghosh was
Lordship,
not here, my lord.
this is a very critical matter, Lordship. I do not have instruction for submission. Kindly, I am praying for short passover. He is busy
I
in
am
court number
suffering a
30.
lot.
Lordship.
My lord.
You start.
Yes, I'm grateful, man. My lord, the first one. Yes, and I do not know whether I am a party or not. I'm the complainant, my lord. You will see, we have not got the writ petition. We have not been made a party.
Who are you?
Lordship, I am the complainant on the basis of which the order has been passed. I'm assuming the writ petition. There are two writ petitions. I do not know. One of them must be challenging the order, cancelling the building plan.
Yes.
Lordship will see the first line of that order.
Is it your building plan?
Lordship.
Is it your building
It is,
plan?
Lordship, building plan with respect to premises bang opposite to my house.
How are you affected?
I'm offended, my lord. I'm affected because, my lord, this the plan has been obtained by forging documents.
That's all right.
There are FIRs which has been lodged by the KMC, my lord.
All right. You file your application. We'll see later. Yes.
My lord.
What is
My lord, let them give a copy at least, my lord. I do not know the
You file an application. We'll see whether you are supposed to be a party or not. Yes.
My lord, my lord, the first one is my lord, 226.
If the plan pertained to your property, I would have made you a party. You are just a neighbor who is a complainant. On the basis of that complaint, actions have been taken.
Have been taken.
That's right.
Exactly. Search.
All
Exactly.
right.
And now that they challenge, my lord.
All right, sir.
I'm
Your
the-
role is over. You are a good Samaritan. You have done your job.
My
Yes.
lord, I was a party lordship in why writ petition.
File
this has been
application.
passed. Maybe I shall file, but I do not know the cost title anything.
Find out. Something called list. You know what is a
This
list?
I can get the short cost title.
Whatever it is, sir, I'm not here to tell you how to find out things. Yes.
Fine. My lord, the petitioners, my lord, numbers 1 to 6 are the owners of premises number 52A Mohendra Sarkar Street, Calcutta, Kolkata, 7,12,000. And petition number 7 is the constituted attorney and the developer of that premises.
What
Number-
6 are the owners?
My lord,
And who are the developers?
7.
7.
7. 1 to 6 are the owners.
All right.
They all are petitioners.
Yes.
Premises number 52A, Mohendra Sarkar Street. Now, my lord, there was an application for sanction of a building plan.
Yes.
And my lord, all the requisites were complied with. And in the building plan, or at the outset, I submit, my lord, in the building plan, the rule 142 of the Calcutta Corporation, my lord, building rules, the opportunity was taken because there was one tenant. Now, my lord, that building plan, regarding the building plan, my lord, all the inquiries are made. Regarding the tenant, there are inquiry by the police authorities. There was inquiry by the corporation authorities. And, my lord, there are several, my lord, RTI applications. And all the applications are replied to. And it was given that the one tenant is there. Even the father.
Who is from the inspection book? It appears that is Joy Saha was the existing tenant in
Only tenant, only tenant.
Joy Saha is the lawyer?
No. He's a tenant.
No.
Oh, no, not that way. Yes, I understood. I know him. Anyway, now, Lord, the building plan was sanctioned. Sanction fee was taken. and Milord, work was started. Then Milord, at the instance of somebody, Milord, a notice under section 411 was issued for stop work. Milord, that notice was challenged, and Milord, that notice was quashed by this honorable court by my Lord Justice Kaushik Chandra. My Lord, thereafter, another writ petition was filed by one of the private parties alleging the complainants regarding the cancellation of the plan, my Lord. And that writ petition was also disposed of by my Lord Justice Chandra, directing the corporation to hear the matter. Now, my Lord, in the meantime, my Lord, there was action taken by the Kolkata Municipal Corporation for, my Lord, the language has been used for what a reconstruction of the IB book or the inspection book. My Lord, the name of the tenant appears in the inspection book. My Lord, your also knows, my Lord, before the assessment is made, there are inspection by a report is filed, then, my Lord, the assessment was made. Now, my Lord, the inspection book was thought to be reconstructed by corporation, and that is also behind the back of the owners. No notice was given, and the power was exercised under section 192 of the Kolkata Municipal Corporation Act. Though, my Lord, 192, my Lord, pertains to the chapter of assessment book, and it has been held by this honorable court that 192 is not available for correction of the inspection book. That judgment I will be placing, my Lord. Now, my Lord, no notice was given because notice is a must under section 192(2). My Lord, behind our back, my Lord, the entire order was passed and name of Joysa was deleted. And it was found, my Lord, the order, your Lordship, I have set out the order in paragraph 11 of my application. For our convenience, my Lord, to read it, my Lord, I have annexed the original order also. There is a handwritten. So I have made out that, my Lord. Paragraph 11. What paragraph is it? প্রথম দিকটা 192 order. My Lord, 192 order, paragraph 18, I'm sorry, my Lord, paragraph 18. I'm sorry, paragraph 18. Yes, page 11, my Lord. Your Lordship will get it. My Lord, can you see? After, may I read out, my Lord? Well, your Lordship is already reading it, my Lord. Your Lordship, kindly see. After careful examination of record, it appears that in the scanned copies of IB assessment period of first quarter 2003-2004, no tenant, namely Joysa, was recorded, but in the hard copies of the IB available of the department, Mr. Joysa are recorded as tenant. In the IB of first quarter 97-98 and first quarter 2000-2004, it seems that a tampering was made and the name of Joysa was inserted illegally in the IBs of first quarter 97-98 and first quarter 2003-2004. My Lord, pausing here for a moment, your Lordship, kindly see the requirement of section 192 and the findings. Well, a finding is not proper. Well, they are not sure. It seems, my Lord, that there are tampering. Accordingly, department placed proposal for reconstructing of the IB for assessment period of first quarter 97-98 and first quarter 2003-2004 under section 192(3) of KMC Act 1980, though e-file computer number 1097676 and the same was approved by the Municipal Commissioner dated 1st of January 2025 with concurrence from Honorable Mayor on 24th January 2025. Accordingly, IB of first quarter 97-98 is hereby reconstructed. This is one order. And another order, same language, same thing, that is for different my lord, period. That is for first quarter 97-98. Same language, same thing.
Yes.
Now, my lord, kindly see. My lord, let us, at the outset, my lord, before entering into the merit, my lord, entire order is without jurisdiction on 2 counts. My lord, kindly see section 192.
Para 19 is quoted.
My lord.
Para 19 is quoted.
Yes, my lord.
You have quoted it.
Yes. 192 I have quoted, my lord. Amendment of municipal I have quoted. My lord, kindly see 3 there at the bottom. By striking out the name of any person or any land or building not liable for payment of property tax. My lord, this is 192 relating to the chapter assessment book, not IB. My lord, kindly have a look to the book, my lord, original book. Now, my lord, kindly come to page 13. Page 13, my lord, clause 2. Clause 2I.
Yes.
Incidents of property tax on land and building. A notice of not less than 15 days shall be given to the recorded owner or the recorded person liable to pay tax of the land or building of the place, time and date on which any amendment of the assessment book intended to be made under this section. Any person on whom a notice amendment is served under this subsection may file an objection in writing to the municipal commissioner at least 3 days before the date fixed in the notice, and the provisions of section 186 or 190 shall apply mutatis mutandis to such objection. Then, my lord, this notice was not given. Entire thing has been done behind our back. Entire statutory procedure has not been followed at all. My lord, they are under statutory duty to give us the notice for this amendment. And, my lord, you will also kindly see 192 is not available for correction of the inspection book. My lord, you will also kindly, I am referring to one judgment here. My lord, let me finish my other points. Later on, I go to the judgments. Now, my lord, you will also kindly, this is the first infirmity I am drawing your lordship's kind attention, and you will also kindly see section 192. My lord, section 192. Amendment of Municipal Assessment Book. This is the heading of the section. Municipal Assessment Book. My lord, IB inspection book is not the assessment book. My lord, kindly see the section 191. Then the chapter starts Municipal Assessment Book. You will also kindly have a look to the book, my lord, kindly, my lord. Well, it starts with section 191.
Yes.
My lord, you kindly see before that the heading of the section F, Municipal Assessment Book. My lord, assessment book, your lordship knows, after considering the inspection book, the hearing officer, my lord, assessment is made by the hearing officer for the tax to be paid, and for that purpose, the assessment book is prepared. That assessment book can be amended or anything can be done from 191 onwards, and 192 can be, my lord, if you say, not for inspection book. Inspection, my lord, the person, my lord, the corporation officers who are amending the inspection book, they are not the author of the inspection book. Inspection book is prepared by the inspector. Well, they can accept it or they can reject it. No question of amendment of inspection book. My lord, and reconstruction word which has been used, my lord, you will also kindly see, reconstruction word is absolutely foreign to this section, my lord. There is no word like this, reconstruction. And the word is used as amend. Notwithstanding anything contained in section 190, the municipal commissioner may at any time amend the municipal assessment book. And then 3 is by striking out the name of any person or any land or building not liable for the payment of property tax. Now, my lord, there is a column in the assessment book. Well, I am showing you from the annexures that who are the persons liable to pay tax. Now, my lord, this amendment is absolutely without jurisdiction, not followed by the directions given by the statute itself. This is number 1, my lord. Now, my lord, kindly see. After the first order of, my lord, quashing of the 411 notice, I started, my lord, demolition of the building, and demolition is complete. Now, my lord, kindly see.
Yes.
My lord, I am just referring to certain annexures, my lord. My lord, kindly see, the plan was sanctioned, it is not disputed. That is why, my lord, withdrawal of sanction is there. That is page 45 is the sanction fee taken. Then, my lord, I have supplied the certified copies of the, my lord, inspection book to the corporation. My lord, certified copies of the inspection book I have supplied. My lord, I have given the certified copies. My lord, kindly see. My lord, kindly come to page 49. Page 49, my lord, you will please to see the certified 49, then 50 is the original certified copy. My lord, kindly have a look to the certified copy. Page 59. There, my lord, the name of Joysa is appearing. From the certified copy, has your lordship got it at page, my lord, 50.
59.
50. At page 50 is the certified copy itself. My lord, here, my lord, the name of this person is appearing, Joy Saha. Has your lordship got him, my lord? My lord, here, my lord, on the left side top, here, my lord. If it is taken in this way, my lord, in the reverse manner, then it will be easy to understand.
Look at the kind of document, nothing is clear.
Joy Saha name is there, my lord. My lord, got him, my lord. Let me check in just a second. My lord, kindly have look at the position. I marked it in red color. My lord, kindly have a look to this. Just a quick cost. My lord, kindly have a look. I've given a ring. Got it, mute.
I have to change my power glasses to read this.
But
Like, I'll make it magnifying glass and then I can read it well.
My lord, next certified copy. Next year. In the same manner, that is in the same manner it is there. Now, my lord, these are the certified copies we have supplied. My lord, by the way, my lord, by this time, my lord, kindly have to come to section 54. I am sorry, page 54. It is clear. It is more clear. Page 54, my lord, on the, my lord, left hand side. Plus, you got it, my lord. Name of the tenant is appearing. Rate of rent 310. My lord, the premises number, then thereafter details of last assessment. I got it, my lord. Then, my lord, there is in the first item, I, capital I, R plus hall plus 2R plus 2R plus etc. Dalan etc. Then the name of Joysa is appearing. My lord, got it, my lord?
Yes.
Here it is clear in the certified copy. This certified copy we have supplied. This certified copy was supplied to me by the corporation authorities on my application. My lord, kindly have a look to the applications I have annexed. I have paid the fees and they have supplied me certified copies. My lord, what is the value of certified copy? That we will get, my lord, from section 591 of the Kolkata Municipal Corporation Act.
Yes.
Section 591. Apart from, my lord, the Evidence Act of 76, 76 Evidence Act. Apart from this, my lord, the another section for giving more force to the value of the certified copies, my lord, section 591 is there.
Yes.
My lord, these certified copies are given. Then, my lord, kindly see, page 56 is the order of Justice Chandra, my lord, quashing the 411 notice.
Page?
Page 56. Next page, next page, page 56. My lord, kindly see. A report was filed that was quoted in page 57. Then, my lord, concluding paragraph as fallen from your lordship at the outset at the mentioning of my learned friend, appearing for the alleged complainant, my lord, the observation is there in the last paragraph. Then, my lord, the concluding portion.
Yes.
Then, my lord, the another writ petition was moved. The next page, my lord, page 59 is the order for consideration by the corporation itself, and order has been passed. That is the second writ petition. Now, my lord, you also can see. My lord, can you come to one My lord, can you see, can you come to page 65 capital A? Page 65 capital A. Is the RTI answer, RTI query answer. My lord, question is there, 65A. My lord, question number 2 will also kindly see. Is the premises at 58A Mohindra Sarkar Street, Kolkata, 7,12,000 under what number 50 tenanted? The question was asked. My lord, kindly see the answer. There are so many questions. I am just drawing your lordship kind attention to the answer. Page 68, capital A. Capital A is the my lord, clear copy. My lord, 68 is somewhat hazy. My lord, kindly see. Reply number 2 is yes. Reply number 3, name of the tenant Joy Saha, son of Shankar Saha. Some additional information given by the corporation itself, which is not available from the IB. My lord, now, my lord, you'll also kindly see the another RTI information as 69A. This RTI was sought for by the, my lord, my opposite side, my lord, complainant. My lord, kindly see the answer, number 3. The tenant 2 and 3. Yes, partly tenanted. 3. The tenant name is Joy Saha. Tenant's father name is not recorded, but father name is given in the other not recorded in the IB book. That is correct, but it is tenanted. Now, my lord, without following the procedure, if we take it for granted that they have got the power under section 192 to amend the, my lord, inspection book, then, my lord, 192 has not been complied with. The entire thing has been done behind our back. In spite of this, my lord, all these, my lord, assertions by the corporation itself, they have at the instance of, my lord, of somebody, they have passed this order. My lord, kindly see the order I have quoted. The original order is here in this manner at page, my lord, kindly see. 70 তো আছে, এখানেও আছে। My lord, kindly see the order number 70 after 70, that is 71. Oh, sorry, page number 71. My lord, kindly see the order passed. In this way, my lord, the order has been written. After careful examination of records, yes, this I have quoted in paragraph, my lord, 18. It appears that in the scanned copies of IB for assessment period of first quarter 2003 and 4, no tenant, namely Mr. Joysa, was recorded. But in the hard copies of the IB available of the department, Mr. Joysa are recorded as tenant. That is the IBs of first quarter 1997-98 and first quarter 2003-2004. It appears that a tampering was made. Oh, I'm sorry. It seems, my lord, it seems that a tampering was made and the name of Joysa was inserted illegally in the IBs of first quarter 77-78 and first quarter 97-98 and first quarter 2003-2004. Accordingly, department is, I'm sorry, accordingly, department placed a proposal for reconstructing,
reconstructing the IB for the assessment period 97-98 and
reconstructing the IB for the assessment period first quarter 97-98 and first quarter 2003-2024 under section 192(1)(3) of KMC Act 1980 through e-file compilations, computer number such and such, and same was approved by the municipal commissioner dated 12 January 2025 with concurrence from the honorable mayor on 24th January 2025. Accordingly, IB of first quarter 97-98 is hereby reconstructed. So there is no whisper that a notice has been given and explanation was sought for, and there is a finding that it has been tampered. It is their record. It is lying in their office.
It's a mayor and commissioner, and it's a fraud on statute.
I want to humbly submit, my lord, it is really a fraud by the mayor and the commissioner on the statute, my lord.
It's not tampering by me, tampering by
It is tampering by the department itself, by the corporation officials.
So they didn't come and comply with 192 subclause 2.
192 subclause 2. Incidents of property tax of land and building. A notice of not less than 15 days shall be given to the recorded owner or the recorded person liable to pay tax of the land or building of the place, time and date on which any amendment of the assessment book is intended to be made under this section. Amendment of the assessment book is intended to be made under this section. My lord, this 192(1)(3), rather 192 section itself, the heading is Amendment of Municipal Assessment Book. Or a heading is Amendment of Municipal Assessment Book.
That's what I'm saying, sir. No notice was given to you for before the amendment.
No notice.
opportunity of hearing goes, right of appeal goes.
One opportunity hearing is not given, right of appeal is not given, even no so-called, no my lord, natural justice.
Yes.
In this way, my lord, it has been done.
All right.
192.
Anything else?
My lord, my lord, kindly, I will be placing some judgments.
Show it, sir.
My lord. আমি তো যশোর নজরে পড়বে চট করে পড়ছি এখান থেকে। My lord, I am just referring to one judgment. ওই জাজমেন্টের কপি আছে। It clearly says, my lord, 192 is not available for my lord amendment of the inspection book.
Yes.
But I marked it, my lord. Logically, excuse me. My lord, section 192 Calcutta Municipal Act pertains to amendment of the municipal assessment book. However, in the present case, the issue of consequent erroneous entry in the inspection book, which is unrelated to section 192. So, my lord, wrong exercise of power and non-compliance of the section without an opportunity of hearing. This is absolutely in my humble submission without jurisdiction order. My lord, another judgment, my lord.
Madam, please shut your phone. Yes, show me, sir.
My lord, I'm giving my check. There are two judgments side by side on the same subject.
Yes.
My lord, you logically see, for our purpose, this was a very extreme case, my lord. My lord, kindly have a look, please. এই কপিগুলো সেকেন্ড দিতে আছে যাই হোক My lord, kindly look at the second judgment. My lord, kindly see the second page of the last judgment. The petitioner contends that the names of all the tenants are not recorded in the inspection book maintained by the Kolkata Municipal Corporation. The building in question is in dilapidated and ruinous condition. There was no scope for induct new tenant in such dilapidated building. Only for obtaining maximum floor area ratio by availing the benefit of Rule 142, the Kolkata Municipal Corporation Building Rules 2009, the private respondents prepared false documents of tenancy. The petitioner specifically states that the fictitious persons have been shown as tenants in the subject premises solely to obtain extra floor area ratio. Then, my lord, provisions of section 411 of the Kolkata Municipal Corporation Act has been placed. Both the declarations given by the private respondents have also been placed in the order. Upon perusal of all aforesaid documents and upon hearing the submission made on behalf of all parties, it appears that the petitioner is stretching the argument a bit too far. None of the tenants have raised any objection before the Kolkata Municipal Corporation alleging eviction without due process of law or alleging non-allotment of equivalent space in the proposed construction. Petitioner, being neighbor of the subject premises, ought not to raise an issue with regard to the number of tenants at the that may be inducted in the subject premises. It is always for the landlord to take a decision as to how many tenants will be inducted in the subject premises and the area of tenancy to be allotted to them. Now, my lord, one thing, my lord, if you lordship kindly permit me to submit. My lord, Kolkata Municipal Corporation Act is not regulating the relations between landlord and tenant. There is a specific tenancy law for our state. That is West Bengal Premises Act 1997. There are provisions that if I want to reconstruct a building on a premises, well, I must provide space to them after completion of the building. That is section 11, and that is to be done by the rent controller. Section 11 of the Premises Tenancy Act 1997. Well, there is My lord, in my case, suppose, my lord, yes, I have done forgery, I have done everything, my name, tenant's name is deleted. Then, my lord, if the tenant goes to the court, he has got the document, he has got the agreement, and my lord, he has been placed in a different place for constructing purposes. I am giving the, my lord, rent for that. If he goes to court, that only not for placing me, they in my lord, in connivance with the corporation, landlord does all these things. Well, Kolkata Municipal Corporation is not providing any accommodation to tenant. There is no statutory thing that tenant can enforce by this. Only sanction of the plan is concerned.
So all this is being done by your good neighbor.
Yes, sir. Yeah, and something more has been done. There are the second read. Your lordship, that is more dangerous. That is more dangerous. Before the passing of the order, the mayor declared in the newspaper that the plan has been cancelled. In a press conference. Predetermined matter. I will be pressing the second one. I have annexed the newspapers.
Yes.
My lord, I am praying for setting aside of this order, my lord. This 192, my lord, for deletion of the name of the tenant. Now, my lord, should I place the second one, my lord? That is the consequential writ petition of this order, my lord.
Where the sanction plan has been cancelled.
Yes. Following this, my lord. Following this.
Obviously following this.
Yes. Following this plan has been, my lord, cancelled.
Yes.
Without, that is also without any opportunity of hearing. Time and again I have appeared and I have said, give me the copy, give me the allegations. They have not supplied anything.
Yes.
আমি একদিন গেছিলাম।
Yes.
My lord.
Item 14. 14 also, yes.
I'm grateful. Item 14. Sorry. Just a minute. Lordship can explain. For a minute. What did you call it? ওই ওটা মোটামুটি Now, my lord, following this, my lord, kindly see the sequence of the matter. In this case also, I have given the certified copies of the thing, the orders of the Honorable Court. Your Lordship has already seen that. My lord, kindly second read. My lord, kindly come to. My lord, kindly come to page 67 first.
That's a notice hearing.
First notice. First notice.
Yes.
My lord, before going into this, may I invite your Lordship's kind attention to section 397. What are the requirements there? Then well, it will be easy for us to understand. My lord, 397. Sanction or provisional sanction accorded under misrepresentation. Heading is that, my lord. Misrepresentation. If at any time after the communication of sanction or provisional sanction to the erection of any building or the execution of any work, the municipal commissioner is satisfied, my lord, is satisfied that such sanction or provisional sanction was accorded in consequence of any material representation or any fraudulent statement in the notice given for information furnished under section 393, 393A or section 394, 395, he may, by order in writing, cancel for reasons to be recorded such sanction or provisional sanction, and any building or any work commenced, erected or executed shall be deemed to have been commenced, erected or executed without such sanction and shall be dealt with under the provisions of this chapter. Provided that before making any such order, this is very important, my lord, the municipal commissioner shall give a reasonable opportunity to the person affected as to why the order should not be made. Now, my lord, let us see whether the reasonable opportunity was given or not. My lord, I am just showing your lordship, kindly see. My lord, kindly come to page 67 minute. Page 67, the first notice. My lord, kindly see. That was given on 3rd of March 2025. My lord, got it, my lord? My lord, there, request to appear on hearing regarding premises number 52A Mahindra Circus Street, ward number 50, branch Borough 5. Respected sir, you are hereby requested to appear on hearing under section 397 KMC Act 1980 at the Chamber of Municipal Commissioner KMC 5 SN0 Kolkata 13 on 12th of March 25 at 12 noon with relevant documents. My lord, I am putting question to myself, my lord. My lord, is it a notice providing, my lord, opportunity of hearing, my lord? I don't know what is the case against me. All those, my lord, penal findings are required.
This is notice.
My lord?
It is notice, sir.
Case I don't know. Case I notice, that's all right. Notice of date, that is all right. I don't know what is that. Then on the next page. On getting this notice, my lord, I have given one reply. I have received the notice dated 3rd of March 2025 asking me to appear in a hearing scheduled to be taken up by Municipal Commissioner KMC on 12th of March 2025 at his chamber with relevant documents. Please supply me the reasons and contents giving rise to the hearing as above. Please also supply me all the documents and materials to be relied upon for the purpose of such hearing. I shall bear all costs and expenses for this purpose. Please supply me the aforesaid materials within 2 days from receipt of communication in order to enable me to assist the authority during hearing. This is my reply on 5th of March. Then, my lord, on getting this, next page, my lord, can you see page 69, notice dated 3rd March, it was given on 5th March, when I given that. I have given that. The same thing, same language, only the premises number has been given. Then, my lord, again, on 6th of March, I placed the same request seeking, my lord, the papers and other allegations against me. Then, my lord, you will also kindly see. Again, I received a notice on 12th of, then I received similar notices, and my lord, nothing was given to me. My lord, I have written the notice. On 3rd of March 25, I was served with the notice for appearing for hearing under section 397 KMC Act 1980 at your chamber on 12th of March 2025 at 12 noon with relevant documents. Since I was not served with a notice under section 397 KMC Act describing the facts and circumstances, misrepresentation or fraud, which is sine qua non for the aforesaid hearing under section 397, so it is not possible for a person to come with relevant documents as indicated by the notice dated 3rd of March 2025. I have given a letter on 5th of March 2025 at Borough 4 office for supplying me the reasons and the contents giving rise to the hearing and also the supply documents and materials in connection thereto, but I have not received a single paper from their office. Again, on 4th of March 25, I received a similar letter dated 3rd of March 25 having mentioned the premises number and your office address, but no document or paper in connection with the hearing I have demanded has been supplied. On 6th of March 25, again, I have served a letter demanding the reasons and contents, including the documents and materials in connection with the hearing of the case. Till today, I am not with the knowledge what are the allegations against me and the facts and circumstances and materials led to you form a prima facie satisfaction with the moving of section 397 of KMC Act 1980 for having a hearing as per aforesaid notice. It appears to me that I am going to be adjudicated in penal provision under section 397 of KMC Act 1980 without any opportunity of hearing by non-service of single paper in connection with the materials and documents giving rise to aforesaid case. The proceedings are absolutely illegal, arbitrary, and without jurisdiction. Then, my lord, similar demands are made. Then, my lord, on one day, my lord, illogically page 72. On 12, my lord, page 72, my lord, kindly see. Again, I have written a letter. In terms of your notice under reference, I have attended your office on 12th of March 25 at 12 noon, accompanied by my lawyer, Mr. Kasinath, the advocate, the executive engineer, building Borough 4 and 5, and assistant engineer, building Borough 4 and 5. We are also present due to your busy schedule and engagement. I was informed the matter will be taken up by the additional municipal commissioner. In pursuance of the information, we attended the office of the additional municipal commissioner along with my said advocate and the aforesaid two officers from corporation who also attended the said office. During the course of hearing, the additional municipal commissioner agreed with my advocate that the notices which were served to me were defective. The notices should have accompanied with the allegations and documents expressing prima facie satisfaction of fraud or misrepresentation, which are essential ingredients of section 397 of KMC Act. And also a time should have been fixed for submitting written reply with documents against the aforesaid notice, which has not been done. Well, it was placed in writing that the additional municipal commissioner, he was at par with my learned advocate that these are the things to be required. Those are not given. Now, my lord, illogically see again, notice are given at page 73.
Yes.
No, these are the RTI informations. Again, I have annexed here. Then, my lord, certified copies you have already seen. Then, my lord, kindly come to page 86. My lord, page 86. You will also kindly have a look to this. That is dated 5th of April 2025. That is the newspaper, the Telegraph. Here the mayor, the Honorable Mayor, Mr. Firad Hakim, his photo has been given. No, I will not disturb your lordship with the entire news item. My lord, kindly see the last three lines. Last three lines. We have revoked the permission for the new construction, Hakim added. We have revoked. When he is saying that is 5th of April. When the order is passed, my lord, kindly see. The order is dated 6th of May 2025. After a month, that is at page 113. After a month, my lord, it is predetermined matter that it has got to be done by exercise of 192 tenants inspection book will be reconstructed without notice. Then on the basis of that, the 397 proceeding will be done and it will be withdrawn. Permission will be withdrawn, and that was decided at least on 5th of April 25. And that is not the one paper. My lord, can you see next page? The Hindustan, that is the Times.
Recording the complainant is standing by the side of the mayor and
what the mayor
Yes.
Now, my lord, can you see page 87? Hello, you got it, my lord? The page 87 also?
Yes.
My lord, the next item on the same day, 5th
Yes,
April 2025.
Yes.
Now, my lord, I am seeking your lordship's kindly to show your lordship.
Yes,
my lord, just a minute, lord. One thing, my lord, that is very at a live matter. A live matter that is lying with me, Junior Mr. T. He is just playing it. What Mr. A news item is saying. Joseph. Tell you.
He's your son.
My son, yes.
Yes, tell me. What is this?
This is the, I'm sorry, taking with seniors leave, my lord. This is the press conference by the mayor and the private, I mean, the complainant is standing by the side and briefing him to cancel the proceeding.
That's okay.
Obliged.
Yes, Mr. Ghosh.
Well, he has.
Just a minute, but since 397 order, I have not been placed before your lordship.
Which order?
397 order, cancelling
seen
the
it.
plan. Cancelling the plan.
I have seen it, sir. 113, 114.
My lord, my submission is this, my lord. Ingredients of section 397, there is not at all a finding, and I have to have that, my lord. Nothing.
Finding is there, only tampering which they are alleging.
Yes. Who has tampered?
114, the second last paragraph is the allegation which is there. Yes.
Well, he has raised certain the allegations, my lord, on the issue beside my lord. So far as my case is concerned, the short issue is involved, but he has raised that certain aspects, my lord, which, my lord, if I am to answer, then I am to, my lord, put it in by an affidavit. But so far as I understand this case is concerned, on the basis of complaint, my lord, a proceeding was initiated under section 397. The whole issue is there, my lord, whether a tenant was there or not. This is the entire issue. Because
Where is the tenant, Mr. Ghosh?
My lord.
Where is that Joy Saha?
That is, I am saying, where is Joy Shah?
So all that you have done is.
No. That is, well, tampering. That is, well, that is the findings. Tampering by, because, well, I am not the beneficiary of that, not tampering. Beneficiary of tampering of the person, my lord, who is, my lord, the obtained the sanction of the building plan. My lord, he has obtained the building plan.
That is the allegation.
No, my lord, because, my lord, the 142 is for that. 142 is there. The additional floor area will be permitted if the tenant is there. 100%, my lord, equal to the area in occupation by the tenant.
You file your.
Well, I'll file one opposition because, well, this is not.
You need to file your affidavit.
File.
Take down. The petition in the present writ petition is aggrieved by the withdrawal of entries made in the inspection book with effect from 1997, 98, 2003 and 2004 in respect of premises number 52A, Mahendra Sarkar Street, Ward number 50, Calcutta, comma, by striking of the name of the existing tenant, Shri Joy Saha, by invoking section 192, subclause 1, Roman 3 of the KMC Act in violation of the statutory provisions. Full stop. It is the submission of the petitioner that the building plan qua the said premises was sanctioned on the inspection book for the period 1997-98 and 2003-4 and 2017-18, containing the name of the tenant, comma, Mr. Joy Saha.
2017 and only have got, my lord, the 97, 98,
97, 98, 2003, 4.
Therefore, other
Containing the name
Last
of
one is remaining as it is.
Joy Saha.
That is carrying Joy Saha.
Full stop. One, Mr. Sayantak Das, comma, claiming to be resident of the nearby area, filed RTI. No, you had filed a writ petition.
Writ petition and RTI.
Filed a WPO number 98 of 2015, comma, challenging the inaction of the respondent KMC in considering the application made by him seeking cancellation of the sanctioned plan obtained by the petitioner on the ground that there has been no tenant by the name of Joy Saha in the said premises, and that there has been misrepresentation / tampering of IB. This is a measure assessment book. What is it called?
Inspection board.
IB record
Inspection book.
for the year 1997-98 and 2003-04 in obtaining the building sanction plan. Full stop. This court had disposed of the said writ petition. Wide. What is the order?
26 February 2020.
By order dated 26th February 2025, wherein by directing the respondent to pass a speaking order after affording an opportunity of hearing to all the concerned parties. Full stop. During the course of the said proceeding, the petitioner came to know that the respondents, unilaterally, without giving an opportunity of hearing, altered the IB book with regard to the period 1997-98 and 2003-04. Full stop. Being agreed by the unilateral change of the inspection book, the petitioner has preferred the present writ petition. Full stop. ऊपर पहले आप लिख लेना. The petitioner has filed writ petition WPA number 226 as well as WPO number 425 of 2025. Both the writ petitions are taken up for hearing together. Full stop. Then ये आप लिख लेना. In writ petition number so and so. ये पहला वाला है. हाँ? Writ petition number, this is 425. In the other writ petition, the petitioner alleges that the sanction plan has been wrongly cancelled under section 397 of the Calcutta Municipal Corporation Act in view of the allegation made against the petitioner that he has carried out he has got in view of the submission in क्या लिखा है फिर से बताना. On the ground that there has been misrepresentation of facts by the petitioner at the time of obtaining the sanction plan. Full stop. Learned counsel for the petitioner submits that Joy Saha was a tenant in the said premises, and the allegation that his name has been wrongly put in the assessment book is not correct. Full stop. He further argues that on the basis of such misrepresentation, on the basis of such alleged misrepresentation in the IB book for the year 97-98 and 2003 and 4, his valid sanction plan has been cancelled. He impresses this court with the argument that under section 192(1)(3), under which the 192(1) Roman 3. That's the section, right? 192(1) Roman 3 the change which has been carried out in the assessment book is contrary to 191(2), wherein the petitioner should have been given the opportunity of hearing before any amendment is made in the assessment book. Full stop. It is his contention that he was not given any notice of hearing, and the respondent corporation unilaterally made amendment/changes in the inspection in the measurement book. Full stop. He further contends that the respondent corporation, while cancelling the sanction plan under section 397 of the Calcutta Municipal Corporation Act, should have provided a notice of hearing before taking any decision regarding the cancellation of the said plan. Full stop. He contends that the mayor of Calcutta Municipal Corporation had addressed a press conference and he had made a statement on what, 5th of June? Give the date, sir.
I can't check.
On such and such date, much prior to the issuance of the cancellation plan under section, much prior to the issuance of the impugned. What is the date of the, what is the date?
5th of April.
5th of April, much before the impugned order dated. What is the date of the impugned order?
6th of May.
6th of May 2025, whereby the petitioner's building plan, the building plan was cancelled under section 397 of the Calcutta Municipal Corporation Act. Full stop. Learned counsel for the respondent, KMC, Mr. Alok Ghosh, seeks and is granted 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. Let this matter be listed after 6 weeks.
Well, it is short time, maybe given. All my works have been stopped.
We will see, sir.
It will appear after 6.
No.
It will appear after 6 weeks.
You file your application after 6. Yes. Banerjee. Yes.
The club of Calcutta, the Toligans Club.
That's right.
Private members club.
We can have it next week. Today is 3:30 according to the bar resolution.
Mr. Kaur should not be opposing me, but still he is decided to.
Personally, he will not.
This relates to application of amusement tax, whether it
That's
applies to a club or not. It does not. That's
That's right. We'll have it next week.
Next Thursday, I think.
Next Thursday. Let this matter be listed next Thursday. Not today. Next Thursday we'll have it.
Grateful.
Sorry, I was thinking that maybe we'll finish it off, then I could have heard this. This is very interesting.